Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-7031, Nextera Energy Global Holdings BV and Nextera Energy Spain Holdings BV versus Kingdom of Spain, appellant, and case number 23-7032, Nine Ren Holding S.A.R.L. versus Kingdom of Spain, appellant. Ms. Harris for the appellant, Kingdom of Spain. Ms. Fay, amicus curiae for the European Commission. Ms. Wingle, amicus curiae for the United States of America. Mr. Dworsky for the appellees Nextera Energy Global Holdings et al. And Nine Ren Holding S.A.R.L.
Good morning, Ms. Harris.
Good morning. Thank you, and may it please the court. Sarah Harris for the Kingdom of Spain. The Foreign Sovereign Immunities Act bars jurisdiction over Spain. First, the arbitration exception doesn't apply. That exception requires federal courts to confirm for themselves that an arbitration agreement exists. None exists here. EU law is paramount international law for EU members like Spain and EU nationals like the investors. EU law has always deprived EU members of any power to agree to resolve intra-EU disputes outside the EU system, including through arbitration. Second, the waiver exception doesn't apply. Foreign sovereigns don't implicitly waive their immunity just by ratifying arbitration treaties. Foreign sovereigns must also agree to arbitrate with particular parties. And third, the investor's position would upend settled international law and make the US a haven for suits that investors' home countries forbid. The settled rule is that when the EU itself ratifies a treaty, as here, the EU controls intra-EU relations, and the treaty doesn't supplant EU law.
Ms. Harris, you mentioned that the EU and the member states ratified the treaty, and under the Foreign Sovereign Immunities Act, we look not only to whether the nation state has, under the arbitration exception, whether the nation state has agreed with the counterparty, but whether it's entered an agreement for the benefit of other parties. And here, I take it you don't dispute that the EU and Spain entered into an agreement for the benefit of the investors.
We dispute that the relevant agreement, I guess, is the Energy Charter Treaty. So we think that the agreement here is a very specific one to the extent one exists at all. It would be between Spain and the individual investors.
Well, what do we make of, I mean, we're interpreting the Foreign Sovereign Immunities Act, and for purposes of this question, the arbitration exception. Is your position that the parties then who have to submit their disputes to arbitration have to be the same parties who entered the agreement for the benefit of others?
Our position is there's only one arbitration agreement here because the Energy Charter Treaty itself seems to recognize that. And
well, the court and BG Group and the Chief Justice as well talk about sort of the relationship between two agreements, an agreement to settle disputes by arbitration that could be the treaty, and the agreement creating a standing offer for investors.
that's true, but I think the relevant precedents here would be the later Supreme Court decision in ZF Automotive, which discusses the type of investment treaty we have here, as well as the Olin decision from the Second Circuit, which is sort of surveying this, and looking at the Energy Charter Treaty itself. So if you look at Article 26.5 in particular, I don't think you can construe sort of whatever background is going on with member states or not as the relevant arbitration agreement, because Article 26.5 recognizes that to have the type of arbitration agreement required under both ICSID and the New York Convention, you need both consent given by the sovereign together with the written consent of the investor. And those two things together are what would satisfy the requirements under ICSID and the New York Convention.
So why does the ECT not satisfy that test?
Well, here we don't think that there is any, Spain does not have the power to agree to arbitrate with these investors from European countries. And so the missing ingredient here is the consent given by Spain. In the words of the European Court of Justice.
But the ECT contains an unconditional agreement to arbitrate, and Spain signed that. And we have held in at least 2 cases, Chevron and Stillix, that this type of agreement in a treaty married with a request for the arbitration consistent with what the treaty requires is sufficient to confer jurisdiction, at least on a prima facie level.
So 2 issues with that. First of all, I think there's a preliminary question, which is what law governs whether Spain actually consented in the Energy Charter Treaty or not. And given that this is a dispute between an EU member and EU parties, the primary law governing their relationship is and always has been EU law.
I guess the question is, why is not your position just a question of arbitrability as opposed to a question about jurisdictional facts? Because it seems that if we're just looking at jurisdictional facts, we have precedents addressing the ECT specifically in Stillix and a similar agreement in Chevron, which said that all you need to show is a treaty like this and a request to arbitrate from the investor and an arbitral award. We have that here. And if you have other arguments as to why this doesn't apply, why isn't that just a question of arbitrability, which is not about jurisdiction?
2 reasons. And first of all is this court's other precedents, which seem to clearly establish that whether a party has the power to agree to arbitrate is a question of whether an agreement formed, which is always for this court to decide de novo under the Foreign Sovereign Immunities Act.
Can I ask, which precedents are you principally relying
Uh,
on? The
both-
FAA precedents?
No, I'm particularly relying in the Foreign Sovereign Immunities context on Belize and Micula, but I also can talk about FAA cases because those also confirm the point. And just to walk through the Belize decision, if it were true that all you had to do was take a quick look at whether there was an investment treaty, whether there was a purported agreement, that case would be inexplicable because this court said, no, there has to be a further look at whether Belize's prime minister actually had the authority to agree to arbitrate. This court.
Can I ask you a question? It seems to me that you've conceded that the language in the ECT and the ECT itself does create an agreement to arbitrate with non-EU signatories to the ECT. Is that correct?
That is correct. And that is no but we don't think that that means it's necessarily a question of arbitrability.
No, well, I guess my question is, it's the exact same language that creates an agreement to arbitrate with non-EU countries. And there's no carve out in the ECT for intra-EU disputes. So it's the exact same language. It does create an agreement for non-EU countries, but it does not for intra-EU countries. It's the same language.
So 2 points on that. Just first of all, if you're looking at the ECT itself, we disagree with that reading because, and I would first point you to Article 1.3 of the ECT, which expressly recognizes that economic integration organizations like the EU have primacy and control relations between EU members. And that provision says that
What was the number of that again?
1.3, Article 1.3. And it says that an organization constituted by states to which they have transferred competence, i.e. sovereignty, over certain matters, a number of which are governed by this treaty, including the authority to take decisions binding on them with respect to those matters. So even
Is your position any different from what it would be had all the current members of the EU been members and the EU only on its own behalf had joined the ECT?
I don't think so. The reason why the EU joins alongside members is usually there are issues of sort of shared competence in a treaty. And this one, again, is an express recognition that the EU is going to have primacy in certain regards. So it's
But your
not.
answer to my question was that your position is the same as it would be if the individual member states had not joined, but only the ECT had joined. That's,
Only the EU.
I'm sorry,
Sorry.
only the EU. Thank you.
Yes, and the reason is when the EU joins a treaty, it's sort of it's demarcating with respect to individual members that there are matters within the exclusive competence of the European Union between the members. That is how 28 signatories unanimously understand the Energy Charter Treaty. That is how signatories across the world understand other treaties, like the World Trade Agreement in 1995.
You mentioned the Belize case, but Belize case doesn't really get you out of the questions I think that Judge Pan and I were asking, where you have a background treaty that under which the parties have agreed to arbitrate with respect to third parties, that was just a bilateral situation. You're talking about the competence of the change.
Sure, and two responses on that. Micula, I think, is very squarely on all fours, albeit an unpublished decision, but this court is saying in Micula that it is a jurisdictional question whether the bar on intra-EU arbitration precluded Romania from entering into an agreement. And just more broadly, the idea that there is a distinction between bilateral treaties and an international agreement respectfully puts the cart before the horse. The question in the first instance is, could Spain consent to take certain types of disputes outside the EU system? Did the parties to the Energy Charter Treaty understand that Spain and any other EU members were doing this? And any way you look at it, under any sort of choice of law principle, either because you agree that when EU members and nationals are doing anything, the primary law governing their relationship is EU law, or because under the Energy Charter Treaty itself, the EU joining Article 1.3, the other principles in Article 26.6 recognize that EU law has a significant role to play and cannot allow.
So shouldn't the EU and Spain just withdraw from the ECT if that's the case? Because they have signed an agreement that unconditionally agrees to arbitrate, and now they're saying we can't sign that agreement. It seems the EU and Spain are still benefiting from the ECT. Their nationals can arbitrate against non-EU countries and have all of these benefits. But they're saying that they don't have to sort of pay the price. And it seems to me that if they have a problem and there's a conflict between the ECT and EU law, then they need to resolve it themselves, not through coming to court like this, but just withdrawing from the ECT, which in no uncertain terms says is an unconditional agreement to arbitrate.
But respectfully, that would contravene the way every signatory to the ECT that has ever weighed in on this issue understands the treaty. So it would be really strange to force signatories just to withdraw.
Sorry. What do you mean? What do you think everybody's agreeing to? Because I think there's a dispute here as to whether you can arbitrate or not.
There is certainly a dispute with the investors, but among signatories to the Energy Charter Treaty, 28 of them, and no one has said otherwise, everyone interprets that treaty to mean that Spain and other EU members never agreed to arbitrate in the EU system. And that's not a surprise given the backdrop of the treaty. The idea of even having intra-EU arbitration was unheard of until the mid-2000s. And whenever it cropped up, when it started cropping up, then the European Court of Justice immediately made clear in the Ireland decision.
I want to go back to what you said before, because we have an amicus brief from international scholars. And they note that when the ECT was being negotiated and drafted, there was a suggestion that we have a disconnection clause, which is something that would carve out intra-EU disputes. And they chose not to do that. It was actually considered and not done. But the EU did carve out this Svalbard treaty concerning an archipelago in the Arctic, but you never carved out intra-EU disputes. And the plain language of the ECT says that you're unconditionally agreeing to arbitrate these disputes, even among the European countries. And what you pointed to me before, Article 1.3, is just a definition section. It's not a disconnection clause.
So a few responses. First of all, the EU offered the disconnection clause only if necessary, and it is superfluous because when the EU itself joins a treaty, the EU is making the treaty part of EU law. Now, Article 1.3, of course, is a definitional section, but it's still highly significant that the definition of the EU is as an organization to which states transferred competence and that the EU can take binding decisions with respect to matters within the treaty. So it is defining what the EU does, but it's saying that matters governed by the treaty are subject to the EU's competence, including the power to take those decisions.
Svalbard. You're reading a lot into this definition.
Well, I don't
not say that. I'm looking at it right now.
Respectfully, I don't have to just rely on Article 1.3. I am also relying on the significance of the EU joining a treaty. This is no different from the WTO agreement from 1995. There also was a disconnection clause proposed for that treaty. No one has understood the idea that you propose a disconnection clause only if relevant to mean that the EU somehow lacks the authority to make EU law on this. And on the Svalbard issue.
I'm sorry, so are you saying that at the time that they drafted the ECT, everybody understood that it would not apply to intra-EU disputes?
Yes, I am absolutely saying that. And not only am I saying that, that is evident from the signatories' understanding of this treaty.
But ACMEA and Comstroy had not been decided yet.
Yes, but ACMEA and Comstroy are applying settled principles that date to 1957 in the EU system. And so it is not just the case that these were principles that were only discovered in 2018 or later. They are principles that have undergirded the entire EU system since its formation. Article 344 of the Treaty on the Functioning of the EU sets out in very plain language that member states who join the EU no longer can refer disputes outside the European system if they are intra-EU disputes, that it is not allowed to do so.
What if Switzerland and the United States had a treaty that predated the ECT and that incorporated sort of first options versus Kaplan, you know, your idea about verifying the existence in advance of the validity of the arbitration agreement in advance. And then they claimed that the ECT, even though they're signatories, and ICSID, even though they're signatories, are subject to a different jurisdictional inquiry than the inquiry that one would ordinarily make in an ICSID case applying the ECT. That's also international law, is it not?
So that would be international law. I think the question is, we're all in the same world, I think, of deciding which conflict principles apply. And we have three options that have been on the table from both sides, under which we win. The first of which is that European law is the primary law governing relations between EU members. That's what everyone expects, investors, nationals, members alike. Second of all is the general principle that the specific governs the general. The EU treaties are themselves international law and are the most specific rules governing the capacity or power of EU members.
You're saying that general law is more specific than the ECT that contains an explicit agreement and consent to arbitrate? How is that more specific than the ECT?
Because the ECT is silent with respect to power to agree to things. And not only is the ECT itself is internally conflicting, but does not have a rule saying, you know, this is the rule for capacity or power to agree.
Does your position boil down to Spain signed the ECT, believing it could agree to this unconditional arbitration agreement, but they were wrong? They weren't able to sign that?
Absolutely not. What we are saying is Spain and everyone else, again, all 28 signatories who have weighed in unanimously saying this, that when an EU member, such as Spain or anyone else, signs the ECT, especially when you have the EU joining, what it is agreeing to is arbitrating with non-EU members. And so that is what is agreeing to. It is
Why
not.
wouldn't you just say that in the treaty then? Because it says the complete opposite in the plain words of the treaty.
Respectfully,
It says every signatory or every contracting party is agreeing to an unconditional arbitration.
And you could say the same thing for the UN Convention on the Law of the Sea and the WTO agreements. And the understanding at the time is that when the EU itself joins a treaty alongside members, there is no power to sort of say, oh, you know, we thought that this meant to supersede primary EU law that governs these relationships. It is clear to everyone. And again, I can't emphasize enough how unusual it be for a court to sort of say that all signatories who have weighed in just got this totally wrong. They have been operating under this understanding.
But your position relies on this sort of fiction that at the time they assumed they knew what Comstroy and ACMEA were going to decide.
So respectfully, no, it doesn't rely on that fiction. It relies on the understanding that when the EU members formed the European Union in 1957 and agreed to a provision that put off limits any sort of dispute resolution that did not let the European Court of Justice have primary decision-making responsibility, that was not allowed. They gave up that power. And
A fundamental question.
You a question
Let's
about arbitration, because that's what we're focusing on here. When the EU signed the ETC, it knew that arbitration was different than litigation, so that parties could agree to arbitrate a matter where they would reach an agreement through the arbitration process that would not be appealable. They would be bound by it, but they had a choice of going that route or litigating. So why do we read this treaty in a manner that assumes that the EU did not know what commercial arbitration was.
Respectfully, I don't think it's a matter of reading the treaty as if the EU doesn't understand arbitration.
Well, what did it mean by arbitration, commercial arbitration then? In the understanding that one of the reasons post-World War II arbitration was so desirable was you could avoid the costs and delay of litigation. And surely the EU and its leaders were sophisticated enough to realize that. All I'm getting at is if it joins a treaty where it embraces the understanding of a term in a commercial field, how can it come back years later and say, oh, that's not what we meant? I'm just trying to understand where your argument goes.
Yes, and our
You
argument is
accept that arbitration, commercial arbitration at least, among parties was
Yes,
not a
and-
matter that came through the court system or the legislative system on an individual basis.
And what the EU agreed to and what the member states agreed to is arbitration vis-a-vis non-EU members. It sort of begs the question, who are they agreeing with? It's sort of as if states had
Well,
tried.
they are a sophisticated party. They know who they're agreeing with. They know they're agreeing with sovereigns who are part of the EU, not only an agreement as to countries that are not part of the EU. I mean, you're asking us to assume, and you may be correct, but I just want to be clear about it, that there was either a bit of naivety or ignorance on the part of the EU when it agreed by signing a treaty that enabled independent commercial arbitration.
So respectfully, I think this is like the UN Convention on the Law of the Sea, where it is not naivety or lack of sophistication going on. It is the understanding that when the EU itself joins a treaty, it is taking intra-EU matters off the table. So the agreement is absolutely between the EU members and people outside the EU, but there is no agreement to arbitrate things within EU members.
So when Judge Pillard asked you what authorities you were relying on, you gave her 2 cases from our court, and you dismissed the Supreme Court BG authority. And of course, we can go through those cases and point out how they're factually different. That's why I thought Judge Pan's question about trying to understand what's going on when the EU signs a treaty that calls for commercial arbitration as an option.
Yes, and what goes on, and again, this is the way that treaties have been understood, similar treaties too, and so it would really upend the way these treaties have been read by all the signatories to say suddenly this is not the case. But when the EU signs a treaty, it is fencing off intra-EU relations. And that's not just sort of me saying it, it's also the European Court of Justice repeatedly saying this, including—
Why did all the individual members of the EU separately sign the treaty? If only the EU had signed it, your position would make a lot more sense.
The reason is, and I think, again, Article 1.3 recognizes that some of the matters in the treaty are exclusive competence of the European Union. Others at the time were not. And so that is the practice of the European Union. If there are sort of shared matters, the EU signs and also the individual members. But the key thing is the EU signing and recognizing that with respect to external matters, that is what happened. And that—
You talk about throughout your briefing and your argument that the implications of Comstroy and Achmea are that Spain lacks the capacity, but that is not how those decisions read. Comstroy talks about, as a matter of EU law, the ECT's arbitration provision has to be interpreted as not being applicable to disputes between a member state and an investor of another member state. It goes more to whether Spain did enter an agreement as opposed to whether it could. And so is there anything you can point me to in those decisions, the EU Court of Justice decisions that point to this capacity argument.
Yes. First of all, when Comstre says that the ECT arbitration provision cannot apply to intra-EU arbitration, it is saying that that lacks force between EU members. It's not just sort of, it doesn't apply means doesn't exist. And I think the European Foods decision from the European Court of Justice makes this super clear. It's going over those cases and saying that the consent, quote, lacks force, which is sort of the typical language you would expect if it was a lack of power, lack of authority argument of the type this court has.
It can be that it's invalid, which is, and I understand and appreciate why you're using the capacity argument, because I think that's your strongest footing in a very tough battle against ICSID. And we haven't even talked about the full faith and credit aspect of ICSID. But so the logic underlying the position is that an international tribunal or an arbitral tribunal can't interpret EU law because it's not part of the EU judicial system. But fundamentally, I don't understand what the threat is to the EU judicial system and the EU courts' primacy in a kind of a Murray versus Madison sense as interpreters of EU law, because arbitration awards are not precedential. So you end up with, is your position that private parties can't settle energy disputes within the EU, or private and state parties can't settle disputes based on a misapprehension of EU law?
Our position is what the European Court of Justice said in Comstre and in previous cases, and why this is part of one of the foundational treaties on the EU, which is that the EU justice can actually develop this body of law, dispute resolution mechanisms that are outside of that do not respect the primacy of EU law, undermine the system that is being built in the EU. They leave, even when it's an arbitral decision where you sort of say it's just an award, you can decide whether or not to enforce it. Those are extremely important interpretive questions of treaties that the members of the EU agreed, at least in matters among them, would be subject to the European Court of Justice. And that's
what about settlement?
Settlement, with respect to, you'd have to, I suppose, have a dispute brought somewhere in the outset.
Spain and Ioan and Nextera decide to settle this case. And they have ideas in their own minds about EU law and what it means. And they just settle and they don't publish anything. They talk among themselves. They are interpreting EU law. They're not, it sounds like your position is requiring everybody to litigate, which is, as Judge Rogers was asking, like, there are some benefits to having some disputes arbitrated. So you're saying, no, they cannot be arbitrated, period?
And I'm saying within EU members, it's not just me saying that, that is the European Court of Justice's position, longstanding position from 2006, when it said the UN Convention on the Law of the Sea, which is also a multilateral treaty. You have 2 EU members who try to invoke the arbitration provision there. The Court of Justice says, no, that is taking disputes outside the system. It is a fundamental affront.
Does this mean that nobody can arbitrate within the EU? Because what about private parties?
So Comstre, paragraph 65, says that the limits of this are respect to EU member and EU nationals. It's not speaking to private arbitration.
It's the same principle. The whole idea about arbitration is parties are agreeing to it, consenting to let this arbitrator just decide this case. And it saves time, like as Judge Rogers said, where we're not litigating and we're just going to abide by this. It's an agreement among the parties. And it has no precedential value. It has no precedential effect. So it doesn't affect the primacy of EU law. It doesn't affect the EU's interest in making sure the law is consistent. And if it does, then why is that different from private arbitration that interprets EU law?
Respectfully, the European Court of Justice truly has said in many, many opinions that even arbitration, if it involves an EU member and an investor or another EU member, really does offend the system. Because
I understand. My question is why?
Yes, and the why is because as part of forming the EU, to develop a coherent body of law and to ensure that EU
non-precedential. So how is this part of
because it's
developing a coherent body of law?
It's taking a dispute that should be developed by the European Court of Justice out of the European Court of Justice.
You're saying they have to litigate.
We are saying between EU members that is what people agree to. And it does not, the Comstre decision, the European Court of Justice has not.
So that means any EU member cannot arbitrate.
And in between each other, that is,
Ever.
so yes, that is, you cannot do that because it's not an arbitral, unless the arbitral tribunal were allowed to have de novo review by the European Court of Justice. This is what that court held.
So you also say that no tribunal outside the EU can decide an issue of EU law, but you're also asking us to apply EU law, right? So under your reading of Achmea, it violates EU law for us to decide this case in your favor. I'm not really following how that, it doesn't run afoul of the very principle on which your case rests.
No, our argument is that because EU law governs, you should apply what the European Court of Justice has said and respect that it has interpreted EU law as governing and has interpreted EU law clearly. We obviously understand.
You just said you want us to apply EU law.
Yes, and so the argument is not courts can never resolve a dispute involving EU law in any context. The alternative would be what Spain is supposed to argue, like EU law never applies. Where Spain is arguing there's no jurisdiction over Spain under the Foreign Sovereign Immunities Act in the first instance. In order to
so hold, we would have to apply EU law. And Achmea is saying our International Arbitration Tribunal can't even apply, let alone interpret EU law, but you're asking us to apply it.
So what we're saying is there are contexts in which obviously EU law has to be applied. This is one of them. And that in order to avoid the issues with letting parties circumvent their obligations here, there's no other choice. I mean, Spain can't sort of get up here and say, what, like no EU law applies?
The other choice is full faith and credit. I mean, there's no question that Spain is a member of the ICSID and that this case was arbitrated under the ICSID and that we as a US court are bound to give that award full faith and credit. And so that award has done its job in deciding what you claim is a threshold jurisdictional question that would otherwise be for us. So we decide that, but we're bound separately by the ICSID treaty, ICSID convention to give full faith and credit. So why is our job not done?
Because that would both create a circuit split and do violence to the Foreign Sovereign Immunities Act, which is the only source of subject matter jurisdiction. 1650A, which is the full faith and credit provision for ICSID, is not a source of subject matter jurisdiction. The Foreign Sovereign Immunities Act requires federal courts to assure themselves that they have jurisdiction, and just sort of outsourcing the jurisdictional determination to arbitrators does not do that job and would be flatly contrary to the way this court has actually done an inquiry into whether questions are arbitrability or existence of the arbitration agreement. Not only—
What's your circuit split?
The circuit split is with the Second Circuit. The Mobile S.A.R.L decision very clearly holds that you can't just use the New York Convention or ICSID as if they're sort of separate bodies of law. And Amarada Hess from the Supreme Court also says the only source of jurisdiction over foreign sovereigns is the Foreign Sovereign Immunities Act. You can't just look to the ICSID convention.
But we
can't look
would
to
be
something else.
applying the Foreign Sovereign Immunities Act
But what
in conjunction with the ECT.
And Mobile S.A.R.L was
understand the
under the
circuit split.
waiver exception, not the arbitration.
But the principles it's applying are the starting point for the inquiry is that the Foreign Sovereign Immunities Act does not sort of allow you to look to other treaty implementing provisions as if they supply subject matter jurisdiction. This court still must.
We look to facts and decisions. I mean, we look to the existence of an agreement to arbitrate. We look to whether there's an award. I mean, those are facts in the world that we have to honor and credit in order to make our own immunity decision under the FSIA, don't we?
I think it would be contrary to also this court's decision in Belize and even Chevron and Stillix to sort of say, you're no longer going to take a look at whether the question is one of formation or arbitrability. And if it is one of formation, you're no longer going to look for yourselves whether in Belize case, for instance, the prime minister had the power to agree to arbitrate. Those cases don't make any sense under the other side's view that you're just sort of checking boxes and looking if there's an agreement to arbitrate, because all of those cases also involve delegation clause.
Weren't those cases New York Convention cases, not ICSID cases? I mean, we're in a very different situation, I think, under ICSID because of the full faith or credit. It's an extremely powerful treaty in terms of the credit we have to give to the arbitration?
Well, two responses. First of all, the Micula decision, obviously not precedential, but did involve ICSID, and this court and Judge Mehta and the district court did a very fulsome analysis. It would be flatly incompatible with the idea that the ICSID convention meant you just sort of drop pencils and say that the issue is delegated, there's an award, you're all done. And with respect to ICSID, again, relying on the idea that you give an award full faith or credit still puts the cart before the horse, because that is what happens if there actually is jurisdiction under the Foreign Sovereign Immunities Act to begin with. But otherwise, you'd have circumstances, potential circumstances, in which you are not actually ascertaining for yourselves whether an arbitration agreement exists. You're sort of rubber stamping whatever an arbitral tribunal might or might not have said on this. And again, that is contrary to both bedrock principles of arbitration everywhere. I would point you to the China mid-metals decision that we cited from the Third Circuit, because that decision canvasses both Foreign Sovereign Immunities Act, international practice, domestic Federal Arbitration Act practice, and I think just refutes the idea that ICSID is somehow a sort of super-powered convention that allows you to bypass the jurisdictional inquiry that applied. If that's what
I'd like to ask a question about the injunction, if I may. There's a lot of talk about comedy with respect to this injunction. And isn't it Spain who acted with a lack of comedy by bringing a suit in another country just to stop the proceedings in the US courts?
Absolutely not. Spain's only choice in order to enforce its obligations under EU law and to cease circumvention of those obligations was to try to bring suits in the investors' home countries, which is where you would expect litigation to be brought. And comedy interests that this court talked about in Laker Airways are about the singular affront that would happen from subjecting a foreign sovereign to.
I think comedy is a little bit broader. It's about respecting proceedings in foreign courts. I think there is definitely a very strong interest when there's a sovereign involved. I accept that. But it just seems to me that that's the entire goal and purpose of the suit brought by Spain, and I guess the Netherlands and Luxembourg, was to stop the US proceedings. That seems to be a lack of comedy on Spain's part.
Spain is respecting, I mean, again, I'm not sure what Spain was supposed to do in order to enforce its EU law obligations, in order to say that there is.
I guess what Spain could have done is allow this proceeding to go forth while trying to confirm whether or not they have to pay in the EU courts, and then ask for a stay of these proceedings while that's being decided. It just seems that trying to just stop these proceedings, it's very much like Laker Airways, except I do understand that the party is a sovereign and not a private company. But the whole purpose of it was to stop the US suit for confirmation of the award.
And I think if you bought that view, anti-suit injunctions against foreign sovereigns would suddenly become commonplace in US courts, because you would be saying, I guess would be asking only, is there some attempt by a foreign sovereign to stop litigation in the United States? And if that were the test, again, it would not be the case that across the world, foreign sovereigns would virtually, it would be unheard of to enjoin foreign sovereigns.
It seems to me that there are cases not like this one, where they're just parallel proceedings going on in foreign courts and US courts. And then it's kind of trying to get to the end and who's going to get there first and then assert res judicata or whatever. But this is a different kind of case, which is, it's more like Laker Airways, where the whole purpose of the litigation in Luxembourg and in the Netherlands was to stop this litigation. And it seems to me that if all sovereigns subject to ICSID could go and just try to stop investors from trying to apply ICSID, ICSID would just collapse. If they could sue in these national courts to stop ICSID proceedings, ICSID would collapse. And the whole purpose of ICSID is to prevent investors from having to go to these national courts to seek justice, because the idea of it is they should be entitled to a neutral arbiter through this international arbitration system and not be subject to any courts, national courts.
And I respectfully disagree on two fronts. First of all, that Laker Airways is in any way resembling this case. In that case, the whole point was to deprive of any forum for litigating antitrust claims. Again, the whole point of Spain's litigation is that these claims only properly belong in the investors' home states or within the European Union. So that is the.
Finish your question. I want to.
Sorry. That is the point of what Spain was doing. And second of all, the idea that ICSID is going to collapse if investors cannot bring these suits, or there's some sort of undermining, seems defied by practice, in which Again, the European Court of Justice is holding that there is no arbitration among intra-EU members under ICSID in the European Food Decision, and the collateral consequences of requiring EU members to say and to object to such arbitrations and to claw back such awards. ICSID is not collapsing because people understand, and the signatories understand, that this is just not something that EU members agree to.
Why then didn't Spain go into the Dutch or the Luxembourgish courts to stop the arbitration before it concluded? It seems to me you'd be in a better position.
Spain at that point was attempting to, resist the arbitration every way it could. I don't know the details of when it would have been, whether it would have been jurisdictionally premature to do so. But it's sort of just the question of what Spain should have done as a litigant, I think underscores why an anti-suit injunction is so strange. You're sort of second guessing what a foreign sovereign can or cannot do in litigation contexts. As the United States points out, there's a very strong reciprocal interest in not having foreign sovereigns also second guess what the United States is doing in foreign courts. And again, that is why no circuit court ever has greenlit this kind of injunction and why it would be so extraordinary here.
And even under the injunction that Judge Chutkan put in place, it doesn't prevent Spain from seeking monetary relief through the Dutch and Luxembourgish courts to effectively claw back, to recoup whatever these investors managed to win in the United States. So why doesn't that really lower the temperature, lower the stakes on these proceedings? Because the EU, as unified as you describe it, will in the end come to Spain's rescue.
Well, respectfully, the idea that Spain's litigation choices are supposed to be sort of dictated by others, especially in other countries' courts, is sort of like doubling the offense. It's sort of saying,
Well, I mean, Spain did join some treaties. That's why its choices are being dictated.
and again, we can go through this. Again, Spain's position is that the treaties it agreed to did not involve this type of consent, and Spain's position is consistent with the idea that EU law is primary, is imposing obligations on Spain to resist this sort of circumvention of the EU system, and that if courts...
Isn't Spain just trying to get out of its commitments? I mean, it owes more than $1.3 billion for 16 unpaid investor state awards. It just doesn't want to pay.
Respectfully,
It's got the benefits of all this investment, and now they don't want to hold up their end of the bargain by going to arbitration, which they agreed to in the ECT.
So two responses. One, no, Spain is not trying to get out of something it agreed to. Spain's position throughout has been it didn't agree to this. And second of all, I don't think it's just a sort of opportunistic view of the energy charter.
Let's take a step back. Do you think these investors would have necessarily invested all this money in Spain without the assurance that if something like this were to happen and Spain wanted to get out of it, they wouldn't have a neutral arbiter to decide this dispute?
I'm glad you raised what the investors should have understood at the time they invested and at the time they purported to form these agreements in 2011 and 2014 and 15, because I think the first and foremost thing that European investors in the EU member states understand is that EU law is going to be the paramount law governing the relationship. And the second thing they would understand at the time of these things is that intra-EU arbitration at the time was absolutely unheard of.
So they can't rely on the words of the ECT.
Well, I think what they can rely on is the text of the ECT and going back to it that the EU joined it, which at the time.
Correct. And the text of the ECT says there's an unconditional agreement and consent to arbitrate with an investor that asks for it.
And what
ICSID or under the USCA.
And again, what people would understand from certainly from 2006 onward from the Ireland decision is that when you have such an international agreement, the EU joins it, even if you have an arbitration provision that is exactly like the ECT's, you do not have consent to inter-EU arbitration. Just one other thing with respect to what
Can I just clarify your position? Your position then is that there is no arbitration in the EU in the sense that neither its highest judicial authority could so find, nor its highest legislative body could so provide?
There's no intra-EU arbitration in the sense between an EU member and another EU member or an EU member or nationals. And that is, again, based on what the European Court of Justice has said, that there is just no power to agree to that sort of thing. And it said for all sorts of things.
Neither its highest judicial authority nor its highest legislative authority could provide for such arbitration? In other words, the EU is a closed, I don't know even what to call it, a closed governmental entity.
So the only way it could be provided for would be if you had arbitration and then it was reviewable de novo by the European Court of Justice.
Well, that's
So-
not arbitration. I mean, we've discussed what is arbitration and why parties have sought arbitration, particularly commercial parties. So your position is that there can be no arbitration among commercial parties who are members of the EU, period. That the EU's highest court and the EU's highest legislature neither could provide that power to a member of the EU.
So I think my position, just thinking about where it comes from, is Article 344 of the
No,
treaty.
but where does it go? That's what I'm trying to understand, all right? And what I hear you saying is there is none and there can be none. And I want to be clear if you have some qualifications on that.
So the
I haven't heard any so far.
The qualifications, I think, are best expressed in paragraph 65 of the ComSRE decision. The limitations are between EU member, so country, or country, EU member, and EU national. That is the full limits of what the European Court of Justice has said on this. And the reason is,
That's not
again,
my question, counsel, and you're sharp enough to know it.
with respect, Judge Rogers, that is the limit that we know. And the other limit is that to the extent there is an attempt to, if you say arbitration is allowed and in the home countries, you're domesticating it and the European Court of Justice can review that, that would also satisfy the limitation. But the limitation just is what it is and always has been since 1957, which
And
is
it can never change is your argument to us today.
you could change it through treaty amendment, but that is not what has happened with the treaties on the functioning of the European Union.
How would
Since
that treaty be amended?
the members of the European Union would get together, which they have done with the treaty on the functioning of
What
the
would
EU.
the treaty say?
The treaty would say that you no longer have to turn to the European Court of Justice as it no longer has primacy. That's one way of doing it.
Who has authority to do that under your argument?
Well, it's a treaty, so you would have to have the treaty signatories do it. Because the understanding of the treaty,
You couldn't sign that treaty.
the EU, it would be a matter about what the EU can or cannot do. So the EU members would be making the treaty, which is
Well,
what
let
they
me
do.
say, your argument, so far as I can see it, cuts off members of the EU in a way that you say everybody understood, but I certainly never understood the EU's position to be what you're saying today. And the cases that have been cited to us, as well as our own authorities, haven't said that in those terms. And as you know, courts are very good, as our lawyers, of distinguishing cases. But I think it's an astounding argument we're hearing today. And maybe the European Commission will confirm it, but in any event.
I mean, respectfully, the European Union is an innovation where sovereigns gave the European Union certain powers. And that decision has consequences and has always had consequences. And that is why the signatories to the Energy Charter
That's
Treaty.
what we're trying to distinguish here. Anyway, I won't belabor this. Thank you, counsel.
Did you reserve time for rebuttal?
Yes, Judge Pillard. I reserve 3 minutes.
As you know, our practice is to give you a time limit, and then we promptly seem to disregard it with our active questioning. So you will have an opportunity for
Thank you, Judge Pillard.
a rebuttal. And we will next hear from the European Commission. And is it Ms. Pei?
Yes, Ms. Pei.
Good morning. May it please the court, Sally Pei for the European Commission. I'm also pleased to introduce Lorna Armati, Petra Nemechkova, and Paul John Lowenthal from the Commission's legal service, who have traveled from Brussels to observe argument today. The investor's position is extraordinary on every level. It ignores the EU treaties, which are the foundational instruments of the EU legal order. It disregards the decisions of the EU's highest court about an issue that's of fundamental importance to the EU structure. And it seeks to restrain an EU member state from pursuing litigation in EU courts on questions of EU law.
Can
This
you
is all
explain, kind of following up on Judge Pillar's question to Ms. Harris, we're trying to understand the EU's interest here because there is this declaration in your brief that this case implicates the EU's authority and primacy and all these things. But given that arbitral awards are non-precedential, how is that a threat to, I guess, the supremacy of the EU courts?
So I think as Ms. Harris was discussing toward the end of the argument, the question really goes back to two key provisions of the EU treaties, which are Articles 344 and Article 267. Under Article 344, the EU member states agreed that they would never submit questions of EU law for resolution outside the EU judicial system. And Article 267 is the other side of that same coin. It provides that questions of EU law must be ventilated through the EU system, and so that they can be referred.
Even if it's non-precedential, because if it's non-precedential, it doesn't affect your case law. It doesn't affect anything. It's just two parties agreeing on something. That's what arbitration is, and it's just more efficient.
So with respect to questions of the Energy Charter Treaty, the Energy Charter Treaty is EU law as between member states.
I guess
so
my question is more basic than that, which is I don't understand why the EU has an interest in not letting people arbitrate.
So the interest really is in ensuring that questions of EU law are developed and ventilated within the European
But there's no
Union.
developing or ventilating happening if it's non-precedential, is there?
Well, it is to the extent that EU members and EU nationals should not be submitting questions outside the EU system. For them to be able to go outside the EU system to resolve disputes that really are internal to the EU and should have been governed by EU law in the first place is
So
quite
what
detrimental.
about arbitrations between EU and non-EU signatories to the ECT that involve EU law? You say that an arbitral panel can decide those.
So in such a case, the questions being presented in that kind of arbitration would not necessarily raise questions of EU law in the same way as a dispute between an EU member state and an EU
Why not?
national
What if
under
they're
the Energy
interpreting
Charter
EU
Treaty.
law?
So I think there could be situations conceivably where if the arbitral tribunal were being asked actually to resolve a legal question of EU law, it's conceivable that the same questions of primacy would arise. I would note that the Court of Justice has not reached this particular question. It's left open. Comstroy seems to suggest that there is a distinction here where if there were a case involving a third country investor.
Just sort of putting the law aside, though, I'm just trying to understand where would you draw this line, where you have decided this principle that, EU courts should decide EU law, and we have private parties settling based on their understanding of EU law. We have private parties arbitrating based on an arbitrator's interpretation of EU law. We have EU members arbitrating with non-EU people deciding questions of EU law. All of these things are happening, and that doesn't seem to be disrupting the primacy of EU law because it's non-precedential.
So with respect to the different scenarios in which that you've referred to, with respect to purely private disputes that might involve questions of EU law as a matter of fact, for example, the Court of Justice, I think, has recognized that those do not raise the same kinds of concerns as you have in Achmea and Comstroy. And that's partly because those arbitrations are not based on an agreement by a member state, a treaty agreement, to take these disputes outside the EU legal system. So I think there's something fundamentally different between two commercial parties agreeing.
So are you saying it's not about the actual substance of the EU law that's being interpreted? It's about the act of agreeing by the members?
At least that's at least a line that the Court of Justice has drawn so far. It has carved out commercial arbitration, and the reason why
But the members have signed ICSID and UNCITRAL, and private parties benefit from that. I'm not sure that I'm seeing your distinction. You say it's that purely private settlements or arbitrations aren't threats because they're not based on a treaty agreement by EU members to take the cases outside, but ICSID is a treaty agreement to take the cases outside the EU court system.
So if I might just back up a little bit and finish the answer that I was going to. I'm
Yes.
sorry about that. So first of all, the question about commercial, the idea is that there are two private parties that have agreed between themselves. The Court of Justice has said that that is not that does not raise the same issues, and for the reason that it's not through a treaty agreement between EU member states. In addition, those kinds of disputes are subject to review in EU courts. To the extent that there may be set aside proceedings at the end of the arbitration, those questions of EU law can still be ventilated within the EU system. Now, turning to the question about ICSID and arbitration agreements that member states have signed, as Ms. Harris was explaining, here Spain did not have the capacity to enter into an agreement to arbitrate disputes between itself and members of another EU member state.
But it has signed ICSID, so a Spanish private entity and a Dutch private entity Spain could enter an agreement that allows those private parties to take their dispute outside. And that's just action by Spain.
So if it were going to be a dispute between a Spanish private party and a Dutch private party, you would not need an investment treaty to do that. That would be a purely that would be an agreement just between those parties.
But the parties want to, ICSID's only with governments.
Correct.
How about UNCITRAL, same?
UNCITRAL, I think that would govern, so UNCITRAL governs commercial arbitrations as well. So you could have a private arbitration agreement between two parties, but UNCITRAL is, yeah, again, that would be a set of rules.
The governments are signatories.
Correct.
I thought you were making a point that the governments couldn't even purport to be signatories to something that affords arbitration to bilateral private party disputes.
So
that wasn't your point.
So I think my point was that there would be no need for a sovereign state to enter into such an agreement that would govern purely commercial arbitrations between private parties.
But they have, no?
So with respect to conventions like the ICSID Convention and the New York Convention, those are not in themselves arbitration agreements. They govern the enforceability and it's a framework for arbitration, but the substantive agreement to arbitrate, even if you're talking about the context of investor state arbitration, that's why you need recourse to something like the Energy Charter Treaty or a bilateral investment agreement. You cannot, unfortunately, simply look to the ICSID Convention and say that is endorsing arbitration
Or
UNCITRAL.
So I understand your
Not
position.
clear that I understand your point about there's no need for a sovereign state, which is a member of the EU, to enter an agreement with a private commercial corporation located in another sovereign state. But wasn't what happened here an example of why it was necessary? I mean, in order to attract investors, the sovereign state was offering tax benefits.
So with respect
Private
to
parties can't do that. And private parties may not be willing to enter a contract that's that financially beneficial.
So I agree with your point, Judge Rogers, that in many cases, investment treaties serve as an important reason for investors to invest in foreign countries. The point with respect to the Energy Charter Treaty and intra-EU investment agreements is that these kinds of agreements never were designed to provide benefits that would apply within the EU. Investment protection within the EU is governed by EU law and EU regulations. And those are the remedies that EU investors should have availed themselves of if they believe.
So I understand that that's your position, and that could be a question of arbitrability versus whether or not there was an agreement. But I want to put that aside for a moment and just say that the EU did sign the ECT, which has language that says there's unconditional consent to arbitrate. Spain signed it too, and there's no disconnection clause that carves out anything for intra-EU disputes. So why can't the EU and Spain just be held to what they signed in the ECT? And if you want to litigate these other issues, It's a question of arbitrability. They got to litigate these issues before the ICSID tribunal.
So first of all, with respect to the disconnection clause, a disconnection clause would have been superfluous here. Member states are already under obligations to accord primacy to EU law. So the purpose of a disconnection clause in any treaty would be only to inform non-EU parties of the existence of the EU and the existence of EU obligations that govern member states that are signing on to this.
I'm just looking at the plain language of the ECT, and that seems to be contrary to what you're saying. I know that that's your legal position, which can be litigated, but the EU and Spain signed the ECT, which has very plain language about arbitration. I know your position. The question is, who do you get to argue that before? If it's a question of arbitrability, it's before the arbitral panel. And I believe you intervened and did argue this position before the arbitral panel, and it was rejected. But in any event, I don't see why the ECT language doesn't control here. And if there's a problem with it, the EU and Spain should withdraw from the ECT.
So respectfully, Your Honor, I will first address the point about whether this court can look at this. And it's not a question of arbitrability. It's a question of the formation of the agreement. And the court absolutely has the ability and obligation to review this question de novo. On the question of the language of the Energy Charter Treaty, I suppose you're referring to the paragraph, Article 26, paragraph 3A, which contains the language about unconditional consent.
Yes.
I would also point you to Article 26(1), which delineates the kinds of disputes that are being contemplated for submission to arbitration. It says disputes between a contracting party and an investor of another contracting party relating to an investment of the latter in the area of an alleged breach will be settled amicably. And then that's the kind of dispute that would be submitted for resolution. Now, I would note that contracting party here is a defined term. So you go back to the definition section. Article 1(2) provides that a contracting party may include a regional economic integration organization. And it's understood that the regional economic integration organization, the paradigm example of that is the EU. And then you look to Article 1(3), which I understand this is quite a complicated.
It is.
Yes.
It's very convoluted. And
Right, but
Section 3 is very straightforward,
Yes.
unconditional consent. And what about
Wait,
Section
but
5?
continue. I want to hear the rest of the example. You say, then you go to Article 1(3).
1(3) is about the regional economic integration organization. And this is the provision that Ms. Harris was discussing with you earlier, which explains that a regional economic integration organization is an entity constituted by states and to which they have transferred competence over certain matters, a number of which are governed by this treaty, including the authority to take decisions binding on them in respect of those matters. And so in an intra-EU situation, the relevant contracting party for purposes of Article 26(1) is the European Union. And so you don't have the requisite diversity between the investor of a contracting party and the investor of another contracting party in an intra-EU situation. So that's the textual argument for why this particular.
Can you address subsection 5, which says the consent given in paragraph 3, together with the written consent of the investor given pursuant to paragraph 4, shall be considered to satisfy the requirement for written consent of the parties to a dispute and or an agreement in writing for purposes of Article 2 of the New York Convention. There's also a provision that says this is an agreement to arbitrate.
So paragraph 5 is the paragraph that provides that you need both consent in paragraph 3 and written consent by the investor to create an arbitration agreement for purposes of these, for purposes of the UN Convention and the UNCITRAL rules and the ICSID Convention. The reference to the consent in paragraph 3 then refers you back to dispute, which is governed by 26(1). That defines the universe of disputes that are being contemplated could be submitted to arbitration. And again, you need diversity between the contracting party and the investor of the other contracting party. In an intra-EU situation, there is no diversity because the contracting party is the EU, as recognized by the inclusion of the Regional Economic Integration Organization clause.
You mentioned in your brief that the European Commission is considering whether to permit Spain to pay these exit awards. I wonder if you have any update on any progress in that.
So that's correct. The commission's deliberations on this are still ongoing. Spain has notified all of these awards to the commission, and unless and until the commission renders its decision, Spain is not permitted to pay them under EU law.
And I had also asked Ms. Harris this, but what's your position on whether this court is prohibited by Achmea and Comstroy from applying EU law, or why we're not in our FSIA determination?
So with respect to your FSIA determination, the question, of course, is whether an arbitration agreement exists. And the Court of Justice has spoken clearly on this. You are not being asked to do anything other than to take notice of what the Court of Justice has said and to apply that as a question of fact in determining your whether the agreement exists as a question of jurisdictional fact for purposes of the Foreign
Although,
Sovereign
for
Immunities Act.
example, the EU has not characterized its ruling in terms of the capacity of Spain. So we would have to be doing something interpretive, not just accepting some kind of legal fact and applying it. But that's not in violation of those very decisions.
No, I think, Your Honor, I think that to understand why this is a question of capacity, I think the reason why the Court of Justice did not refer to it in those particular terms is because this really is a question that is sort of inherent to how the Court of Justice conceives of the EU treaties. It's useful to remember that when EU member states join the Union, they are transferring certain parts of their sovereignty to the Union. Member states assume obligations and they agree that the EU treaties will have primacy over their national law and other international agreements. And that brings you back to Articles 344 and 267. Those are very much deeply ingrained. And as a matter of the way that the EU is structured, when EU member states join the Union, they essentially give up their ability to agree to anything that would be contrary to the EU treaties. So it is very much a question of power and capacity, even though the Court of Justice did not use that particular term of art.
Judge Rogers, did you have any other questions?
Thank you. No.
Thank you very much.
Thank you.
And now we'll hear for the United States as amicus, Sharon Swingle from the Department of Justice.
Thank you, Your Honors, and thank you for the court's invitation to be heard on the issues presented. I'd like to make just 3 basic points. First is that in determining whether a court has jurisdiction over a foreign state under the FSIA's arbitration exception, the court must make an independent determination regarding the existence of an arbitration agreement. I think that is a legal principle that is clear from this court's cases, which treat the existence of the arbitration agreement as a jurisdictional fact that must be established. In Belize, for example, the court evaluated whether the prime minister lacked authority to enter into the arbitration agreement. In Ecuador, the court held that a district court erred when it failed to make that determination as part of its jurisdictional analysis. And in Micula, the court reviewed whether Romania's ascension to the European Union nullified its agreement to arbitrate. Your Honor asked Judge Pillard about whether any of those rules applied ICSID rules. And Micula, of course, that was an ICSID arbitration. But I would note that Belize also involved arbitration under rules that gave the arbitral tribunal authority to conclusively decide its own jurisdiction and to conclusively decide the existence and validity of the arbitration agreement. And yet this court nevertheless independently reviewed that.
But you do acknowledge there's a difference between deciding if there's an agreement and whether it's a question of arbitrability, because that seems to be.
We do, Your Honor, and we understand that to be the distinction the court drew in Stillex. And I think that same distinction flows from the arbitration cases that the court looks to. In District Number 1, for example, the court recognized that the question of formation was one that could not be delegated to the arbitrator to decide and was necessarily for the court.
So it doesn't seem like your position would be inconsistent with the view that there is an agreement based on the ECT and I guess what we said in Chevron Stillex. We have this treaty, we have an award, we have an agreement by the investor under the terms of the treaty to arbitrate. your position is not inconsistent with that. The agreement is the ECT.
We do
Nextera.
not take a position on whether in fact there is a valid agreement here. I do want to take issue
Under
with,
the ECT.
yes, but I do want to take issue with one point. In our understanding, the ECT is not itself an agreement to arbitrate. And I think just an example will establish why that's so. For example, I do not think a foreign state that is a party to an ECT, to the ECT could invoke arbitration against the wishes of an investor. We understand the
Yes,
ECT to
yes.
be a standing offer to arbitrate.
Correct. It would be in combination with
Right.
the acceptance by the investor and then the
That's
arbitral
correct.
award under our case law.
And do you have a position on whether the ECT is an agreement for the benefit, an agreement to resolve issues by arbitration for the benefit of others?
So again, we don't understand the ECT itself to be an agreement to arbitrate. And
I'm asking the specific question, though, of the FSIA has its own language.
yes, and I want to look to that. It's again, that is that description of which may arise to enforce an agreement made by the foreign state with or be for the benefit of a private party to arbitrate. And again, I think that is envisioning an arbitration agreement. I think that is the
But
jurisdictional
why isn't it
fact.
an agreement among the contracting parties to arbitrate?
Because I
the
think
benefit
in
of-
some instances, you can have third-party enforcement of an arbitration agreement. A third-party beneficiary of the arbitration agreement might.
And why isn't that what we have here?
So again, we're not taking a position on the bottom line of whether there is in fact an agreement to arbitrate here.
So could I just clarify one thing in my own mind? When the United States, in its first point, that at least as to the FSIA, the district court faced with an enforcement petition must make an independent determination that there is an arbitration agreement. By that, I assume that the United States is saying it's not enough for the district court to defer to an EU arbitrator's conclusion.
That is absolutely correct, Your Honor. We think the court needs to make its own independent determination.
Does that mean in the nature of a summary judgment proceeding, potentially, or maybe a trial?
If there are disputed jurisdictional facts, potentially, yes. You know, I think generally it would be our view that this would likely be legal issues to be decided.
Yes, I understand, but I just want to understand where we're going here, potentially. Because depending on the evidence, it may not be possible to resolve this matter simply on a procedural Rule 56.
And that's possible, Your Honor, as is typically the case in FSIA cases, if there are disputed questions of fact that are necessary to be resolved to address the question of whether a particular exception to foreign sovereign immunity applies.
So do you know, and there's no reason you should necessarily, whether or not throughout the world, when a party has an award and seeks its enforcement, there are independent determinations as to whether or not that party is properly before the court, and there is no deference as to whether or not the agreement on which it is seeking exists?
So I do not know, Your Honor, but I think that is unsurprising. And I would just, to return to the ICSID Convention, I think it's clear that the ICSID Convention sets out a framework for arbitration, but it is not an agreement among states to waive their sovereign immunity. That's clear from the convention itself, which references sovereign immunity only to make explicit that it is not abrogated by the convention. And it's clear from Article 54, which provides that a state party with a federal constitutional structure like ours agrees to enforce an arbitration agreement as if it were a final judgment of the courts of a constituent state. So under US law, that requires that there be a basis for subject matter jurisdiction under the FSIA. And I would note that the convention was implemented domestically through 22 USC 1605A, which doesn't itself abrogate sovereign immunity and doesn't provide an independent basis for jurisdiction over a foreign state. That's governed solely by the FSIA.
But there's an argument, if that's that immunity is not abrogated with respect to execution, and the Investors Council points out that the limits of that abrogation imply that the immunity may well be abrogated, in their view, is abrogated with respect to, recognition and enforcement.
So I think both textually, that's a dramatic overreading of the convention to take by negative implication that the parties meant to waive sovereign immunity.
Well, it certainly doesn't expressly preserve it except with respect to execution.
Well, I don't think it's consistent with Article 54 either, because the obligation to enforce an arbitration award as if it were a final judgment of the courts of constituent state envision enforcement under domestic law, which in this case incorporates whatever you need to do to show that sovereign immunity doesn't apply. And I would also just point to the legislative history of 1605A, which was the implementing legislation. Obviously, the legislative history strongly suggests that it was understood that the convention was not waiving sovereign immunity. If you take a look at the Second Circuit's decision in Mobile Cerro Negro, it outlines that legislative history. But I also think it's not the kind of clear statement we would expect to constitute a waiver of sovereign immunity from suit. Certainly that would not be sufficient to waive US sovereign immunity.
Going back to the arbitration exception, what about ICSID and the full faith and credit clause? You say in your brief that dismissing for lack of jurisdiction would not run afoul of the ICSID full faith and credit obligation. But is that, doesn't the full faith and credit encompass or effectuate issue preclusion, claim preclusion, if there's a jurisdictional issue that was decided by the ICSID panel?
I think the court needs to have jurisdiction in order to exercise any power over a foreign state, right? The subject matter jurisdiction inquiry under the FSIA is a threshold question of this court's authority. And again, under ICSID Article 54, our obligation is to enforce the arbitral award in the same way that we would enforce a judgment of a constituent state. And that too, under federal law, would require finding a plenary basis for jurisdiction under the FSIA at the threshold. Now, on the merits, certainly the court would not be reconsidering, assuming it had jurisdiction to enforce, would not be reconsidering the merits of the arbitral award. But that is a different inquiry, I think, from the subject matter jurisdiction inquiry.
So if an investor in Switzerland decided we are going to enter into an arbitration agreement and we are going to give the arbitrators the authority to decide whether we have agreed, whether we have an arbitration agreement, and then to decide under it. And the arbitrators say, yes, you have an agreement, and yes, you've decided under it. We as a US court enforcing that against Switzerland could not credit the conclusion in that award as to the existence of an agreement.
On the merits, certainly.
But not as
conferring subject matter jurisdiction on this court, no. And I think that follows necessarily from this court's prior decisions. In Belize itself, as I mentioned, arbitration took place under rules that gave the arbitral panel the authority to decide conclusively disputes about the existence and validity of the agreement.
And what about Chevron and Stickless?
Well, I think there's this basic distinction that we've drawn between the existence of the agreement and questions about arbitrability. And we understand Chevron and Stillix to be based on that distinction.
And they're finding the existence of agreement based on what?
Well, I think independently examining, for example, in Belize, the court looked to whether the governmental official in fact had authority to enter into a binding agreement to arbitrate.
That's Belize, but Chevron, Stickless, they're where do you see them determining that there is an agreement to arbitrate?
So in Chevron, the court held that the district court had in fact determined that there was an agreement to arbitrate, right? And
Based on the treaty.
right.
That offered arbitration.
Correct.
Acceptance by the
The court,
investor.
the district court had not understood itself to be making that determination as part of the jurisdictional inquiry, but it had in fact determined that there was a valid agreement. And in Still X, the court simply decided that it was a question of the scope of the arbitration agreement. It wasn't a dispute about the existence of the arbitration agreement itself.
Can you address the injunction, please?
I'd like to, Your Honor. I will say, in the view of the United States, this is an extraordinary set of injunctions that Judge Chutkan entered. We are aware of no other instance in which a court has enjoined a foreign sovereign from pursuing litigation in a foreign court. I want to turn, if I can, Judge Pan, to your earlier question about why this wasn't just like Lakers Airways. Because in the United States' view, what's relevant here is kind of the circumstances presented and the real balancing of interests here that make clear what an extraordinary affront to international comedy this is. You know, in Laker Airways, it was an injunction against a private entity, and I think that's extremely significant. Obviously, the affront to sovereign dignity is greatly heightened when you're talking about enjoining a foreign state itself. But in addition, the court in that case was being asked to apply domestic substantive rules of decision to govern the conduct of entities operating in this country whose operations were alleged to be in violation of domestic law to the serious detriment of both the proper functioning of United States markets and US consumers. Here, this is a far cry from that. The underlying arbitration here involves arbitration between a foreign state, a foreign national from an EU member country, addressing questions of EU law. The United States here is acting solely as an enforcement arm of an arbitral tribunal. And I would just add, you know, obviously we have grave concerns about the propriety of coercive measures like injunctions against foreign states. The law of many foreign countries do not allow for such orders to be entered. Countries rightly think that it is a violation of their sovereignty. And you know, obviously we have concerns about the reciprocal treatment of the United States.
Is it your position, though, that there's never a situation in which the United States would sanction or approve of an anti-suit injunction against a foreign sovereign?
We have not.
Where do we draw that line?
We have not taken the position that it would never be appropriate. I think the question has not been squarely presented, but certainly both in this case and in the BAE case we cite, it was the government's view that injunctive relief would not have been appropriate. We don't think it was appropriate here.
So if I could give you a hypothetical, we do have an amicus brief from a party called MOL Hungarian Oil. I don't know if you've read it, but it's supposed to illustrate the importance of the ICSID framework for ensuring that justice is done to investors when a nation decides they want to get out of a deal, and assume this nation is doing it in bad faith, because in this amicus brief, it recounts how Croatia took steps to get out of an investment agreement with MOL Hungarian Oil, which included relying on false information, criminally prosecuting and imprisoning one of the officers of the investor corporation. And in spite of all that, however, MOL Hungarian Oil was able to get an arbitration award from the ICSID framework, and neutral arbitrators found that Croatia was acting in bad faith, that these were false, these were lies, and awarded an arbitral award to MOL Hungarian Oil. And this is supposed to illustrate why ICSID is so important. So what if Croatia had sued MOL Hungarian Oil in Hungary to prevent that company from availing itself of the benefits of ICSID? Would comedy say we can't grant an anti-suit injunction under such a circumstance?
So again, we're not taking any hard and fast position that it would never be appropriate. And of course, I can't speak to the veracity or propriety of the facts in that hypothetical.
Let's assume that they're
amicus
true.
brief.
I'm just wondering if there is room for an anti-suit injunction under narrow circumstances where there's apparent bad faith or something that indicates it would be an injustice.
I would say, I think that the circumstances presented here are a far cry from circumstances that would demonstrate
Are
bad
you
faith.
fighting my hypothetical?
Well, and I want to just point out something that I think is important. Even in BAE, there you had the Korean government going into Korean courts seeking relief under their own law, where you had every reason to think that that was a particularly favorable forum for the home country to be litigating in.
I see
Here,
that as a different kind of case because those were sort of parallel proceedings. This is a suit to stop the US proceedings.
well,
And also in BAE, it looks like there was an injunction, which was lifted. That I was reading that case this morning, and it says there was an injunction entered, which was lifted.
the district court ultimately, when it came before this court, there was no injunction in place.
Correct, but earlier in the proceedings of that case, you said there never has been one.
Well-
It looks like there was one in that case.
I misspoke, Your Honor. I think there's every reason to think that the EU courts where these proceedings are taking place would have no reason to be unduly favorable to Spain, right? Spain has gone into the home court of the investor to try and get that court, which is under the EU rubric and framework, to decide questions of EU law.
I don't want to opine on what the motivations of the EU courts are or anything like that, but I thought that the whole reason for ICSID was to ensure that there would be a neutral arbiter, that investors don't have to go before national courts. They get to go before international arbiters. And the United States is a signatory to ICSID and has 150 cases out there with American investors availing themselves of ICSID. And doesn't the United States have an interest in making sure the ICSID framework doesn't collapse? Because if nation states can file suits to enjoin people from using ICSID, that's a threat to ICSID. And the United States is a member of ICSID and has an interest in making sure that doesn't happen.
So again, Your Honor, it is true that the United States is a member of ICSID. I think that the United States' interest in acting purely as an enforcement court for an ICSID arbitral award is not the same kind of interest that this court had before it in Laker Airways, where even there, where the injunction ran purely against a private entity, the court recognized that it was an extraordinary circumstance, but that in that case in particular, the domestic forum's interest in adjudicating questions of US law to apply to regulate conduct of companies doing business in this country and availing themselves of the legal protections in this country. I think
But I guess my question is whether the United States' interest in upholding the ICSA framework is something similar or akin to, this interest in US law.
we do not see the interest as the same. And I would point out that, this is not merely a hypothetical circumstance in which an injunction against litigation could harm our foreign relations, but we have no reason to think that is manifest. What we have here are statements.
I think it's what?
It's not purely hypothetical that the injunctions here are harming our foreign relations and our relations with our international partners. We have statements from the EU here about the interference with the resolution of complex questions of EU law that the injunctions pose. We have the European Union and relevant foreign sovereigns have raised diplomatic concerns directly with the State Department. I think they all just reflect the significant affront to foreign relations that those injunctions have caused.
Is there room for a very narrow path to upholding an injunction like this? Because these are very specific circumstances where the foreign case is one which is directly targeted at stopping jurisdiction in a US court. It's not just like a parallel proceeding based on the same facts. The purpose of these suits brought by Spain is to stop this ongoing legal proceeding in the United States. And it's under circumstances where these investors won't get to, I guess, have the benefits of ICSA or probably have their awards at all, because we know how the EU feels about these awards. It just seems that it leaves the investors in a difficult place. It seems to me that in Laker Airways, we said that the test is we have to examine the equitable circumstances to determine if the antecedent injunction is required to prevent an irreparable miscarriage of justice. And I don't know how this all balances out, because I do understand that this is different from Laker Airways because we're talking about a sovereign. And I just don't know, how that all weighs. It just seems that there are also other circumstances here that aren't considered in Laker Airways.
So I think it's not just that it's a foreign sovereign here that makes this case different from Laker Airways. I do think the nature of the domestic court's interest is reduced here. And I would just, if I can, Judge Pan, it is true that the European proceedings are intended to stop the domestic litigation, but it is routinely the case that at least the practical effect that a foreign litigant who's litigating both in domestic courts and in some foreign proceeding is going to be to nullify the effect of the domestic judgment. That was true in BAE Airways, where Korea was looking for a Korean court adjudication that it would be able to recoup whatever payment.
But those were just parallel proceedings, which is a little different.
But I
in
think
my eyes, where somebody's just trying to stop something from happening here.
I think it is correct that the fact that a foreign proceeding is for the purpose of short-circuiting or stopping the domestic litigation in US court is a relevant factor, but
Didn't Spain behave with a lack of comedy by doing?
I don't think it's a dispositive factor, Your Honor. And I don't want to speak for Spain, but I would assume that Spain's view is that it has been forced into arbitration that it cannot validly agree to, and then put at risk of facing awards that it can't comply with consistent with EU law. But again,
So your view is its interest, it may be using this tool, but its interest is closer to the heart of at least what it perceives to be its sovereign prerogatives than the US's interest as an exit signatory in being a forum for enforcement.
correct, particularly when the underlying questions are one,
Is not US law, not US parties.
a treaty
not
to which
US
we are not. Yeah.
consumers, not.
If the court has no further questions.
Thank you very much, and we appreciate your submitting a brief and appearing today at our invitation. And now we will hear from Mr. Boretsky for Nextera and Ioan. Morning.
Good morning. May it please the court. I'd like to start with the ICSID
I
issue.
was hoping that you were going to pronounce your name so that I could see that I pronounced it.
No, you got it correctly. I'd like to start, if I could, with the ICSID waiver issue, but in my time also, of course, address the arbitration exception as well. ICSID is an extraordinarily broad convention. Spain's position in this case would effectively tear down the ICSID regime without regard for the US's own obligations under ICSID, which the United States recognized, for example, in its filing in the Second Circuit in the mobile S.A.R.L case. There's jurisdiction here under the waiver exception because by ratifying the ICSID convention, Spain waived immunity to ICSID award enforcement actions in member states' courts. It would create a circuit split with the Second Circuit in Blue Ridge to hold otherwise. It would also be at odds with the Australian High Court's decision, which followed Blue Ridge to hold otherwise. The ICSID convention is a unique treaty that governs disputes with foreign states and waives by its terms immunity to award enforcement in courts of member states. We get that first from the text. If you walk through the text of ICSID, Article 25(1) of ICSID talks about how the jurisdiction of the center shall extend to any legal dispute arising directly out of an investment between a contracting state and a national of another contracting state. So from the outset, ICSID is contemplating disputes against or involving contracting states. Article 41(1), again, a very broad provision, talks about how the tribunal shall be the judge of its own competence. And Article 41(2), that includes that any objection by a party to the dispute that the dispute is not within the jurisdiction of the center shall also be considered by the tribunal. So the tribunal decides its own jurisdiction. That's delegated to the tribunal. Under
So
Article
help us
53,
respond, if you would, counsel, to the arguments that we heard this morning. Because certainly through Judge Pan's question, you got the notion that the court has been reading the plain language. But we're told that there were a lot of understandings, there were a lot of assumptions. Everybody knew, and of course now we have this more recent statement by 26 sovereigns in the EU. What is going on here? Can you help us understand?
Judge Rogers, I don't think that any of those arguments go to an understanding about ICSID. I don't think there is any argument that the terms of ICSID mean anything other than what they say, including that the award is going to be binding on the parties and that every contracting state has to recognize an award and treat it as if it were a final judgment of a court in that state.
Correct, but you heard counsel take us through articles saying that there is language here that limits that understanding, that not only was commercial arbitration not at that point, at that time, but the economic aspect of what's going on has changed dramatically since that period immediately after World War I. So your position is that those limiting articles need to be read how?
So Judge Rogers, I think that those arguments go to the language of the ECT rather than to the language of ICSID. If the court would
agreement to go into ICSID, and I think that's really where the action is, and it feels like the parties are sort of ships passing in the night on that.
So I don't think we're ships passing because I think there are two distinct grounds on which the district court had jurisdiction. The waiver exception doesn't require you to look at the ECT because the waiver is by entering the ICSID convention. And the reason that I was marching through the text of the ICSID convention is that I don't think there can be any dispute that that text waives immunity as to enforcement of ICSID awards, including in the courts of any member state, which under 1650A includes courts of the United States. Then there's the arbitration exception. Under the arbitration exception, a few points on this. First, this court's cases in Chevron and Stilex set forth the framework, and not just the framework, but in Stilex dealing with the ECT specifically for how to determine whether there's jurisdiction under the arbitration exception. Stilex tells us that producing copies of the ECT, the notices of arbitration, and the tribunal's decision show that the arbitration exception applies, and that's exactly what happened here. Stilex treated the ECT as the arbitration agreement because, tying this to the language of the FSIA, it is an agreement made by the foreign state, right, contracting parties to the ECT, with or for the benefit of private parties, which is again what we have here. A key quote from Stilex is that, quote, the tribunal's jurisdictional grant derived from Moldova's signature on the treaty itself. That's treating the treaty itself as the relevant agreement. And under our law, it is up to the tribunal to determine what the treaty means. Spain's arguments, Judge Rogers, about what the ECT means under that language in Stilex are for the tribunal. If you don't view the ECT as the relevant agreement, a sovereign could always frame every challenge as one of existence by saying, well, because the right kind of investor or investment wasn't involved, there was never an offer, there was never acceptance, there was never agreement. Stilex and Chevron reject that. In those cases too, in Chevron, Ecuador said there was no agreement because the treaty's arbitration clause didn't apply to the investments. The court rejected that because that's an issue that was decided against Ecuador by the arbitrators.
Within the scope, but so back to Stilex, you're reading the FSIA. I was just looking for that to put the language right in front of me. The parties to the relevant agreement to arbitrate end up being different from the parties to the dispute that's being arbitrated. If you just track through the FSIA's language, that does not bother you, or how should we?
I think that is the FSIA's language. The FSIA's language was contemplating investment treaties. Investment treaties are different in kind from ordinary commercial arbitration agreements where you have party A and party B signing an agreement, and then usually you're going to have party A and party B, the ones in arbitration, but even then you can have a third party that can sometimes force an arbitration agreement. Here in A6 of the FSIA, Congress is specifically contemplating this kind of agreement where you have an investment treaty among states for the benefit of private parties. When Congress added A6 to the statute, it was trying to expand the scope of enforceability of arbitral awards. And this is exactly the kind of agreement that it was contemplating. And again, STOEX and Chevron, following BG Group, treat the ECT, the investment treaty, as the relevant agreement.
So you have an agreement, you have to enforce an agreement made by the foreign state, Spain, for the benefit of a private party, investors such as your clients, to submit to arbitration all or any differences which have arisen or which may arise between the parties. So there, the parties are not the parties to the agreement made by the foreign state, because the parties to that are the other signatories of the ECT. But that doesn't bother you, that between the parties suddenly becomes the nation state and the third party beneficiary?
No, because I don't think that private party at the beginning of that sentence is referring to the same parties as the ones who will be in the arbitration. Now, necessarily will be in the arbitration.
I thought that was your position, that the benefit of a private party is the investor.
Well, I'm
and
sorry.
then it's a dispute that arises between the parties, and that is no longer the parties to the agreement made by the foreign state.
Correct.
It is now the parties to the differences which arise.
Correct, which can
So
be
it's the same party plus
the foreign state.
the foreign state.
Right. And
Awkward, that shift.
I think it just reflects, and this court's decisions in Chevron and STOEX do as well, the nature of an investment treaty where states are getting together to reach an agreement in order to ensure that that the parties within those states have access to an arbitral forum.
So it seems to me that there are really two ways to look at whether there's an agreement to arbitrate. One is the way that Judge Pillard was just asking you about, which is just to look at the ECT and see that as an agreement among the contracting states to agree to unconditional arbitration for the benefit of private parties, such as your client. And then the second way is to look at it the way we did in Chevron, which is to say there's an offer to arbitrate with any investors out there by Spain because they signed this treaty and it says I'm unconditionally agreeing to arbitrate. And then it's accepted when an investor files its notice of arbitration. And then they get an award. And those are the three jurisdictional facts we need under the FSIA. Those seem to be two different ways to say that there is an agreement to arbitrate. I'm just wondering if one is better than the other, or if there's a preference as to which is more persuasive.
So I think that there are two agreements to arbitrate that could be at issue, which I think is what Your Honor's question is getting at. There is the ECT, which is an agreement to arbitrate for the benefit of a private party. Then there's the agreement that is formed when the notice is submitted, and then that's a further agreement between the private party and the state. What this court said in Chevron and STOEX is that, consistent with the FSIA's plain language, that first agreement qualifies under the FSIA for purposes of establishing jurisdiction. And so that would be the relevant agreement to look at. And if that were not the relevant,
The one among the states
once you have the ECT, it's indisputable that the ECT exists. Spain signed on to it.
Yeah.
That is the agreement that satisfies A6 and that establishes subject matter jurisdiction, and that establishes the way of sovereign immunity establishes.
But either could satisfy A6. Either of the two ways of looking at it?
I was just going to say, well, you can answer that because
I'm
I have
interested.
a follow-on question.
Well, I think the reason that the better way to look at it is that the ECT satisfies that agreement, is that the ECT satisfies the agreement requirement, is that otherwise, if you look at a case like Chevron or STOEX, where you have a state coming in and saying, yes, we agreed to arbitrate, but we didn't agree to arbitrate about this issue. The way that, under Spain's argument, that is always going to become a question for the court rather than a scope question. Because Spain's view of the world is because we didn't agree to arbitrate about X, we never made an offer to arbitrate about X, and no agreement was ever formed.
But under Chevron, didn't we decide that that's just a question of arbitrability?
Yes, precisely. That is a question of arbitrability. It's a question of scope for the arbitrator.
Yes.
And that's precise. The court did that in Chevron because it viewed the ECT as the relevant agreement.
But I'm sorry.
No,
Your
no.
sentence. I
No,
don't wanna
please.
interrupt.
That's okay.
But don't you have the same problem if you go back, one step earlier as you're doing and saying the ECT is itself an agreement to resolve disputes by arbitration? You disavow that it's an agreement between Spain and your clients because your clients weren't parties to it. But it is an agreement to resolve disputes by arbitration. But Spain would come back and say, yes, but it's only an agreement by EU member states to resolve disputes by arbitration with investors from outside the EU. So the very same problem of, well, what's the scope of, Ecuador's offer to arbitrate arises with respect to the interpretation of the meaning of the ECT. And their view is that has to be decided by us. It's our jurisdiction. How do we resolve that?
But Judge Pillard, it is the same sort of question about scope as the one that Ecuador raised. And this court in Chevron and in Stillex decided that that was a question about scope for the arbitrator.
I find that under theorized, and I would love your help to bolster what we are bound by on that point. Because if the nature of the treaty itself is, yes, Spain's a signatory, but Spain is a signatory to a treaty that, with respect to Spain, only allows non-EU investors to accept its offer to arbitrate. That's their understanding, and that's actually the dominant European court understanding. How does it get you an agreement to arbitrate? How does it transform a formation question into a scope question through the magic of adding ICSID and stirring?
So I think there's no question that the ECT is an offer to arbitrate. If you had a Japanese investor come in, there's no question that they could accept the offer to arbitrate. The only argument that Spain is making is we need to construe the terms of this indisputably existing agreement. The meaning of this indisputably existing agreement, that takes us back to the quote that I read earlier from Stillex. The meaning of the treaty, once we agree that the treaty exists and that Spain has signed on to it, which is indisputable, the meaning of the treaty is a scope question. That's the logic of Stillex. That's equally true whether we're talking about the kind of investment or whether we're talking about, within the language of the ECT, what it means to be a contracting state. And the language of the ECT as to what it means to be a contracting state is clear and unambiguous. There's no limitation on the offer to arbitrate with entities that are organized in accordance with the law applicable to contracting parties.
Except in Spain's view, the limit that is the instinct in the entire nature of the capacity of EU and EU states to join such a treaty, which is, well, of course, primacy of EU law. Of course, this doesn't speak to our in-house, internecine, intra-EU.
Isn't that
Judge.
foreclosed by Stillex?
Well, I think it's foreclosed by Stillex. I also think it's at odds with the Vienna Convention and how international law fundamentally works. Under Article 6 of the Vienna Convention, there's no question that Spain has the capacity to enter into a treaty. Under Article 6, there's no question that Spain has the capacity to enter into a treaty. What Spain is doing is it's claiming to discover decades later that as a result of internal EU law, there was actually some prohibition on doing that. Under Article 46 of the Vienna Convention, a state can't use internal law in order to escape its international obligations unless the limitation was manifest and goes to a question of fundamental importance of that state's law.
What's the source for that?
That's the Vienna Convention, Article 46.
And
The-
that is their view. I mean, Ms. Harris, I think quite clearly is saying, oh yeah, manifest and of fundamental importance the whole time. You may have overlooked it, but that has to, I think, be their view. And I guess one question is, can that change? Could that now be the case going forward?
I
I know it wouldn't affect your client.
I don't think it can, because the Vienna Convention talks in the past tense about what was manifest. And
But let's say you're a new investor today, would you be on notice given the much more vocal and
no,
manifest?
I still don't think you would, because what Spain is effectively doing is trying to get out of the ECT or to amend the ECT without going through the procedures that the treaty itself provides for doing that. You simply can't do that as a matter of internal law.
Well, you're characterizing it as akin to domestic law. They're characterizing it as akin to, international law and the plane of the Vienna Convention itself. Isn't it somewhere in between? And if we can synthesize the EU law and the Vienna Convention and the ECT, to what in the Vienna Convention what is not respected by reading the EU law as a species of international law and as having the effect on the ECT that Spain says? I mean, who else does it affect? This is Europe's, however benighted, way of running its own affairs.
So there's a lot packed into that. So it's okay. Let me try to make 3 points. One, under the Vienna Convention, Article 31(1), treaties are contracts. They're construed in accordance with their ordinary meaning. When you look at the ordinary meaning of Article 26(3), it talks about how each contracting party, Spain is a contracting party, each contracting party hereby gives its unconditional consent to the submission of a dispute and so forth. There's simply no other way to read that language other than as Spain consenting. Spain's argument that decades later this limitation was discovered doesn't come close to manifestly showing that language means something other than what it says.
What law are we applying to decide the contract question, in your view? Choice of law question?
Well, I think in terms of reading the contract, I don't know that there is I think you're just reading the contract according to its ordinary terms. I don't know that I don't know that EU law can read each contracting party to mean something other than each contracting party. Vienna Convention 31(1) says you just interpret language, you interpret contracts interpret treaties, that is, according to their ordinary meaning. With respect to the role that EU law plays in the context of international law, there are numerous arbitration decisions by respected arbitrators and scholars that have all but uniformly rejected Spain's argument about the role of EU law relative to the ECT. I would point the court to Professor George Berman's declaration in our record, in the Nextera record, which quotes a number of these arbitral decisions and explains within the system of international law, EU law doesn't have supremacy. It doesn't have hierarchical priority over the laws of non-member states or over rules of international law. The EC itself, in its amicus brief, describes EU law as being akin to federal law that preempts state law within the United States. EU law doesn't dictate the meaning of the ECT as to non-EU members. So this plain language of the ECT, when we're talking about how each contracting party consents, that doesn't mean one thing when Japan looks at the ECT and another thing when Spain or an EU member looks at the ECT. The EU law doesn't dictate the meaning of this agreement for non-EU members. It is a kind of international law in the sense that it governs relations among sovereign states within Europe, but it is not international law on the same plane as the general international law that governs the interpretation of the ECT for all signatories to the Energy Charter Treaty.
I'm not sure I'm entirely convinced that it has to mean the exact same thing for EU investors as for the Japanese investor, given that the two can coexist. Nobody's going to be subject to confusing or conflicting obligations in that.
Well, but I think the problem is that with these multilateral treaties, whether we're talking about the ECT or whether we're talking about ICSID, every signatory state has an interest in ensuring that other signatory states uphold their obligations as to everybody. That's why for ICSID, Congress, consistent with the United States' obligations under that convention, passed 1650A, so that federal district courts have an obligation to enforce ICSID awards. And that's true whether the ICSID award is held by a US investor or by a foreign investor. All countries that are signatories to these treaties have an interest in ensuring that other countries honor them. And so, yes, Japan does have an interest in ensuring that the ECT means the same thing for a Japanese investor as for a Dutch investor.
Does it? If all the investors in Europe said, oh, we can't take advantage of that, we'll just live without it. And Japan is like, well, we're going to take advantage of it. And like the world would go on. There's nothing.
Well, if the investors in Europe don't want to take advantage of it, they don't have to accept the offer and arbitrate. They can go to court if they choose to. And sure,
Right.
Japan.
And if they're told like EU law, we're going to fine you if you do it, or we're going to shun you if you do it, or whatever, that doesn't work through the ECT. I'm just not sure that I see the uniformity point, but I take it, and I don't want to dwell on that. Can you address the full faith and credit obligation? You don't mention it when you're analyzing the arbitration exception. Is that the instrument by which the jurisdictional determination of the ICSID tribunal comes into our case and binds this court?
So I think that's what this court recently said in Valores, that 22 USC 1650A requires a US court to give full faith and credit, quote, even as to questions of jurisdiction, end quote. And that's exactly what we have here. Spain pressed the very same arguments about intra-EU law to the tribunals and to the annulment committees in both of our cases. And under the ICSID convention, those arguments were considered and rejected. The whole point of the ICSID convention is that when that happens, the role of a member state's court is just to ensure the authenticity of the award and then to enforce the award. Again, that was this court's decision in Valores. And
there's a waiver as to enforcement in ICSID. There's not as to, I'm switching back to waiver.
sure.
But there's not as to execution. So what happens next if we were to affirm the district court?
So as to execution, the FSIA's rules about execution in 28 USC 1609 and 1610 would apply. So it's true. ICSID does not waive, the ICSID convention does not waive sovereign immunity as to execution. Instead, it says that the country in which the award is enforced, its rules about execution will apply, and that is supplied again by 1609 and 1610 of the FSIA. And there are various exceptions to sovereign immunity that we would be able to satisfy under the FSIA as to execution.
And I just wanted to give you an opportunity to talk about the injunction. And I wonder what you think is the U.S. national interest that's promoted here by the enjoining the proceedings in Europe.
Sure. So it's two interests. One is the district court's interest in protecting its own jurisdiction. Congress enacted 1650A that requires district courts to enforce ICSID awards. Spain's tactic here was to try to defeat the district court's jurisdiction by bringing suit in the Dutch and Luxembourgish courts. And so the one interest is in protecting federal district court jurisdiction. The other is the injunctions were necessary to uphold the United States obligations under the ICSID Convention and under 1650A. Article 54.1 of the ICSID Convention says that a court must recognize an ICSID award as binding as if it were a final judgment of a court in that state. 1650A implements that within the US as a statutory matter. Again, every signatory nation that signed on to the ICSID Convention took on an obligation to ensure that those awards are enforceable, because that's really essential for the system to function. Is that you
we
could
would be, I mean, Judge Chutkan enforced. If there were no injunction, she would still have enforced. She'd done her duty under ICSID. And the rest is beyond what, I mean, ICSID doesn't have a requirement of enjoining other countries, other signatories, courts. The jurisdiction in this case would have been exercised.
But Judge Chutkan, I think, needed to enter that injunction because Spain initiated these actions in the Netherlands and Luxembourg in order to terminate the district court proceedings and prevent Judge Chutkan from enforcing. They're seeking extraordinarily high monetary penalties against Nextera and against 9REN for every day that they don't comply with a European court injunction to dismiss the US action. So the whole point of these European actions was actually to prevent Judge Chutkan from ever getting to the point where she could enforce.
So if the anti-student cases went forward in the Netherlands and Luxembourg, anything still pending here would be suspended and stopped if it prevailed, including an appeal, including any attempt to, I guess, execute a judgment.
Correct, because the relief sought there. And again, Judge Chutkan did not enjoin the entire proceedings in the European courts. She allowed some aspect of those to proceed, and that was showing comity to Spain and to the European courts. But she narrowly entered an injunction that prevented that relief in the European courts that would have interfered with US jurisdiction and prevented the suits from going forward.
So what's allowed to proceed under her?
Declaratory relief, a determination about the state aid issue. She didn't enjoin those things from proceeding because those were not directly stopping the US action. But as this court recognized in Laker Airways, and I know that Laker Airways didn't involve a foreign sovereign, it involved a private party, but it talked about the importance of comity. And it said that comity gives way when a foreign lawsuit, quote, is specifically intended to interfere with and terminate a US lawsuit. That's precisely what we have here.
Why under ICSID? Because I think you're right that we do have an obligation under ICSID, but why isn't it correct to understand our obligation under ICSID to have our courthouse doors open to foreign investors seeking to enforce ICSID awards? What in ICSID requires us to read it as that our courts must remove overseas obstacles to make it easier for foreign investors to find their way into and effectively use our courts?
It's not about making it easier, but Article 54.1 of ICSID says each contracting state shall recognize an award and enforce the pecuniary obligations imposed by that awards within its territories as if it were a final judgment of a court in that state. It's not just about making the US courts open. It's that if the US courts are asked to enforce, each contracting state shall do that, shall enforce.
It's a little bit challenging. I mean, and this is always the case with international transactions and litigation. If the government of some country said its investors come and try to enforce an ICSID award in the United States, and the dictator of that country says to the investor, if you keep doing that case, we're gonna, start killing your nieces and nephews and we'll come for you next. Does the US court have to get involved in ensuring that that doesn't happen?
Well, I don't know that, unfortunately, I don't know that there's much that a US court could do in that situation to prevent the killings. But
it's just saying it's someone else's lawlessness on their own territory with respect to their own national businesses. I'm not sure that I see that as running afoul of our ICSID obligations.
I think it is a different situation where we are talking about enjoining litigation as opposed to trying to stop a killing spree.
Or to threaten people because they're doing litigation. I'm sorry if I wasn't clear, that the idea is unless you draw out of that litigation, we are going to threaten you or take away your business license or all kinds of other activities. And what I'm doing is trying crudely to test how much responsibility to protect our open courthouse doors we have that would involve reaching overseas into sovereign territory and sovereign function or dysfunction of other countries.
So I think the limits of the US's responsibility would probably be tied to the inherent authority of a court. A court doesn't have inherent authority to prevent the dictator in some other country from engaging in the tactics that you're suggesting. I suppose you could enter an injunction. It would be completely meaningless. A court does have the inherent authority to enjoin litigation in this way. That's what Laker Airways recognized. And so then the only question is it any different in this case that instead of enjoining a private party, we're enjoining a sovereign? And
doesn't Laker Airways also talk about a miscarriage of justice? Like, is that a standard, an irreparable miscarriage of justice? And I don't know that this necessarily falls within, the situation before us might not necessarily fall within a miscarriage of justice, such as a dictator killing people's children. But it just seems that if you play this out, it seems that the result of the EU cases seems likely to be that, because I guess all of the EU countries have adopted the Acmea and Comstroy reasoning, that they would grant an anti-suit injunction to Spain, and the investors would just not be able to collect on these awards that they have won going through this arbitral process before experts in international law, because my understanding is that the arbitrators through ICSID are experts, and they're also people who are placed in the pool by the member countries, including Spain.
Right.
And it just seems that it would be unjust. I don't know if it's the kind of, injustice that that outweighs comedy, but it just seems that if we believed that the investors had the correct reading of ICSID, and they just wouldn't be able to proceed, and it would be an injustice. I just don't know if that outweighs comedy interest.
so I think it does outweigh comedy interest for two reasons. One is the reason that the Laker Airways court itself gave, which is that comedy gives way when you're talking about a foreign proceeding that's specifically interfering with US litigation. The other, just to step back a minute, we have Spain coming in here talking about comedy. Laker Airways describes comedy as the mortar that holds together the bricks of the international system. What's corrosive to the international system is to have Spain come in and say that it doesn't need to honor its obligations under the ICSID Convention and under the ECT. And then Spain is arguing that—
the Department of Justice on behalf of the United States basically say to us, when a sovereign is involved, we're talking about an international treaty, this is a political question. And it's the United States position that this is going to harm the United States interests. And that's not something for the courts to inquire into, where it's just a commercial operation as Lakers Airways. It's only money. It's a different calculus. And I'm concerned, how would you respond? I mean, counsel had the opportunity this morning to talk about political questions. She didn't, but it seems to me that's the thrust of what happens when you have a sovereign, an international treaty, and the United States is concerned about its own interests being adversely affected were the court to issue an injunction.
Judge Rogers, I don't think that it's a political question. I think it's a question that is governed by Section 1606 of the FSIA. Under Section 1606 of the FSIA, foreign states that aren't immune, and if we're talking about the injunctions, we're talking about that because we've already concluded that Spain is not immune under either the arbitration exception or the waiver exception. Foreign states that aren't immune shall be treated in the same manner as a private individual under like circumstances. A district court could have enjoined a private party in like circumstances. That's precisely the Laker Airways case. Section 1606.
Party. I mean, all I'm trying to get is somebody to recognize that, we can talk about injustice, et cetera, and who's really right in this litigation. But I just wonder if once you get the United States and you get foreign governments complaining to our government, doesn't the whole nature of the controversy, if it doesn't change, it certainly is different.
I understand why it feels different. I don't think that it is different because under 1606,
right.
once there's no immunity, Spain is treated like a private party. And I understand, of course, that Spain and other members of the European Union are here arguing that they shouldn't be bound by the language that they agreed to in ICSID and the ECT. The Australian High Court was not moved by that when it followed Blue Ridge and recognized that the ICSID convention was a waiver. And actually, under that court's law, it had to be an express waiver. And the Australian High Court found that joining the ICSID convention satisfied even that standard. And so I understand why it feels different, but I don't think that it is different as a legal matter, Judge Rogers.
All right, thank you. And the other question I have is, and this goes beyond any obligations you have in terms of the client that you're representing now, but I just wonder from your practice, why has the High Court for the European Union not been, in my view, clear about this in terms of the position it's now presenting to this court in terms of what the ETC, what the EU intended when it joined the ECT, and why that makes a difference here. In other words, there was a sentence thrown out to the effect that, well, until 2000, et cetera, this type of commercial litigation wasn't very active in Europe. Is that right?
So I don't know as a factual matter, because my practice is as an appellate lawyer, not an international arbitration lawyer.
Experts and briefs.
So I don't know the answer to that as a factual matter, but what I can tell you, again, just going back to the Vienna Convention, Article 46, is that these sorts of too late discovered understandings of plain language of treaties, that may create an issue for Spain within the EU. It does not absolve Spain of its responsibilities under the treaty. Any more than, to give an example, the United States has been a member of NATO for 75 years. We're obligated to defend foreign countries if they're attacked. If a court in the US discovered 75 years later, actually, maybe there's a constitutional problem with spending US taxpayer dollars to defend foreign states, no one would think that gets you out of NATO. That's an internal problem for the US. The EU, decades later, has come up with an objection that they say prevents them from arbitrating under the plain terms that they agreed to. And as a matter, there's no comity obstacle or other obstacle to holding them to those terms.
I have just a few more questions about the injunction situation. I take it, you haven't cited any other cases from a federal court of appeals affirming an anti-suit injunction against a foreign sovereign. There aren't yet.
There are other cases where courts, including this court, have upheld injunctions against foreign sovereigns in other contexts, but not this kind of anti-suit injunction. But that's also because we're not aware of any case where a foreign sovereign has tried this tactic. And this would become a common tactic if the injunction is not available.
Practically speaking, this is a lot of money at stake in the award that your clients have won. What effect would a foreign court injunction have? Wouldn't your clients just proceed and have to pay a certain amount of penalties hoping that the district court would work quickly
The penalties are quite steep.
relative to the amount of money that your award stands.
First of all, I can't speak to how long it would actually take to go back to the district court, conclude proceedings, and ultimately enforce these awards, during which time these penalties would be mounting. But regardless, the penalties provide at the very least a strong incentive for our clients not to pursue the U.S. actions, which again is an interference under Laker Airways with U.S. courts jurisdiction, which, as we discussed, have the obligation to enforce ICSID.
And if you, I mean, one way or the other, assume that the Dutch courts are planning or might at least think they have the capacity to seek to claw back whatever you've gained here. I mean, in the end of the day, there's going to have to be some kind of resolution of those cases.
After the award is paid, if there were some sort of a proceeding later to try to claw it back, that's something we would have to deal with at that time. But that is separate from that would be playing out the internal EU law issue as a matter of EU law. But that's a separate question from the US's obligation
Absolutely.
to enforce the ICSID award.
And my only other question is that ICSID itself has this Article 64, which empowers a contracting party, including the United States, to refer another contracting party to the ICJ. So if the executive branch here is concerned that Spain or Luxembourg is violating the ICSID convention or Dutch courts, violating the convention by trying to stop the enforcement of your client's award here, then couldn't the executive seek resolution in the ICJ?
I think the problem is that the US could be referred to the ICJ by another signatory state because it's not meeting its obligations. And again, the whole nature of this convention is that all 160 or so signatories have an interest in other signatory states recognizing and not second guessing and enforcing ICSID awards. And I think this court in Valores recognized that.
More questions, Judge Rogers?
No.
All right.
Thank you.
Very much. Ms. Harris has reserved rebuttal time.
Thank you. I would just like to go over the decision points because the position the investors would like to adopt would really be a sea change in all of those scores. First of all, with respect to the position that under the Foreign Sovereign Immunities Act, you can just rubber stamp what the arbitrators have already said or treat Spain's argument that it lacks the power to arbitrate as a question for arbitrability that courts don't decide. That would be flatly contrary to the way this court reasoned in Belize, talking about the nature of challenges to the power of a foreign sovereign or its representative to actually agree. Would also run afoul of Stillex, a case that did not involve any EU parties, and was just hewing to this court's line, saying questions with respect to someone had the power to agree to arbitrate formation, always for courts, regardless of a delegation clause. You're questioning whether an agreement that exists covers a subject matter, which is what happened in Stillex, because the question was whether it's a qualifying investment. That always goes to arbitrability. To adopt the investor's position would be to obliterate the clarity of that line and really throw under the wayside the court's decisions in Belize and in Micula. And again, this argument that Spain has been making really does clearly go to formation. It is, again, the idea that Spain could not and did not ever agree under the Energy Charter Treaty. And second of all, were this court to say that the Energy Charter Treaty actually embodied this consent, a whole host of problems ensue. They point to not one case of a treaty in which a court has said the text is somehow clear, yet in contravention of what all the signatories on the record have ever said about it. Especially strange for a treaty the US did not sign, and it would be a real upheaval for the way the actual parties to this treaty are actually operating. And then on the waiver exception, we agree with you.
Wait, you said that's one decision point?
Those were the two decision points I wanted to cover. And then the waiver point, we agree with the United States' perspective with respect to, again, an upheaval, both with respect to the nature of how the arbitration exception works and the understanding of the treaties as not in of themselves waivers. They're frameworks for considering arbitration that require consent.
Thank you very much.
Not yet. Shows up later.
Stand, please. This honorable court is again in session. Be seated, please. Case number 23-7038, Blasket Renewable Investments LLC, appellant versus Kingdom of Spain. Mr. McGill for the appellant, Blasket Renewable Investments LLC. Ms. Harris for the appellate, Kingdom of Spain. Ms. Pei, amicus curiae for the European Commission. Ms. Winkle, amicus curiae for the United States of America.
Good morning, Mr. McGill. You may proceed when you're ready.
Thank you.
So technically, good afternoon.
Good afternoon, Judge Pillard. Is Judge Rogers joining us?
Oh, good question. I believe.
I've been here during the entire,
There she is. Excellent.
but I muted myself and I turned off the video.
Thank you.
Thank you, Judge Pillard, and may it please the court. Matthew McGill for Blasket. In this round two, I would like to start with the arbitration exception. The Supreme Court's decision in BG Group and this court's decision in Stylex demonstrate that there is jurisdiction in this case under the arbitration exception. The central lesson of the Supreme Court's decision in BG Group is that an investment treaty is more than just a unilateral standing offer to investors. It is, quote, an already formed arbitration contract among the signatory states. In the language of the FSIA, then, that investment treaty is an agreement to arbitrate by states made for the benefit of private investors. The Energy Charter Treaty is such an investment treaty. In Stylex, Moldova argued it did not consent to arbitrate with the investor before the court, but this court held that Moldova's signature on the treaty itself sufficed to establish the arbitrator's jurisdiction. That was because in BG Group, under BG Group, the Energy Charter Treaty itself was a contract. If the arbitrator's jurisdiction had depended on the existence of an agreement with that particular investor, then the existence dispute would have needed to have been resolved before the court could have determined that Moldova agreed to delegate arbitrability questions to the tribunal.
Isn't this different though, because that had to do with the issue as opposed to the party?
No, because Spain's argument here is similar. It says it did not consent to arbitrate. Just as in BG Group, its argument was it did not consent to arbitrate. The argument is about the scope of the consent by the investor state. And here, the foreign state here argued it didn't agree to arbitrate this dispute, but not others. That's Stylex. And this court says that's a question of arbitrability.
But they're saying we didn't agree to arbitrate with any EU investors. That's a different question. That's who we're arbitrating with, as opposed to, yeah, we agreed to arbitrate with Blasket's predecessors, but only on, green energy and not on fossil fuel. It's not a question of the parties have an agreement and we're trying to figure out the details of it. As Spain is saying, no agreement with Spain and this counterparty at all.
I understand. So I guess I have 2 points in response. First is that they are both questions about the scope of consent. Different, but they are both questions about the scope of consent. In BG Group, it was, we did not consent to arbitration with people who do not fulfill the local litigation requirement. That's a class of investors. In Stylex, it's, we don't consent to class with this type of investors. But Stylex actually does involve who? Because Moldova's argument in Stylex was that it did not agree to arbitrate with Energo Alliance because the investment actually came through the BVI entity, Deramet. So there was a who issue in Stylex itself. It's not as neatly compartmentalized as Spain would have it. So under BG Group, if you view the agreement here as the agreement to arbitrate, the Energy Charter Treaty itself is the agreement to arbitrate. It is within the meaning of the FSIA, an agreement for the benefit of private parties. That accords, of course, with the whole purpose of the 1988 amendments. In the 1988 amendments that added the arbitration exception, it was to, as the United States says in its amicus brief, it was to streamline, to make easier the enforcement of New York Convention arbitral award in US courts. That was the purpose of adding this exception. It was to eliminate doubt that there was subject matter jurisdiction to enforce arbitral awards in this court. So that when you are looking at the language.
I think this is a hypothetical from your opponent's brief. If North Korea comes in and says, standing agreement to arbitrate, we want to arbitrate against Spain, and the arbitrators wanting ever more business say, great, we'll arbitrate that. And it's just not the case that any offer was ever made to those investors, but the arbitrators say there was, done.
Under the ICSID convention, that doesn't get out of the gate because ICSID itself would not initiate a proceeding. Under the New York Convention, you would require under UNCITRAL rules, there would have to be an arbitral panel that would quickly conclude that there's no jurisdiction here. These panels are not staffed by, by hacks. They are respected international law experts. The second point I wanted to make is that even if you viewed the arbitration agreement as Spain does here at the level of the particular investor, Spain is raising a question of validity or enforceability, not one of capacity or formation. Spain is arguing, in essence, that EU law preempts its decision to enter into the Energy Charter Treaty on the text of its plain terms. Those types of questions of preemption are questions of validity and enforcement. I would point to the Ninth Circuit's case in Unite Here Local and the 11th Circuit's decision in Addicts. These are not questions that go to formation that must be for the court. They can be delegated to arbitrators. The question of whether federal law preempts arbitration can be delegated to arbitrators because it is one of validity. And under the Supreme Court's decision in Buckeye check cashing footnote 1, validity is not formation. So what is more, when an EU member state violates EU law, the action of that member state is not void ab initio. EU law does not, in fact, have preemptive force like US law. Instead, under Article 260 of the Treaty for the Functioning of the European Union, it requires the member state to take steps to comply or face an infringement action from the European Commission. That is why you have all the EU member states saying we're going to withdraw from the Energy Charter Treaty. But Spain has not yet taken that step, but they have indicated their intention at some point in the future to withdraw from the Energy Charter Treaty in order to comply with the Court of Justice's mandate as set down in Comstroy.
And is that a prolonged process?
You mean the withdrawal itself? The withdrawal is effective 1 year after the date of the notice to the Energy Charter Treaty, but the treaty obligations have a 20-year sunset. So finally, I guess the next point I would make is that even if you rejected my validity argument, even if you were viewing this as an issue of formation, it's not obvious to me that Spain should not be bound by its own voluntary submission of this question to arbitrators. Spain itself invited the arbitrators to decide this. And I am aware of, while this is a jurisdictional fact that this court must find an agreement to arbitrate, I'm aware of no precedent that would preclude this court from saying, you are bound by your litigation choice to pursue this in front of the arbitrators.
Wasn't most of the US cases on this are pre-arbitration, but wasn't First Options versus Kaplan was a case afterwards where they went through arbitration, but they're allowed to look back and say, no, this person wasn't bound.
I think that
it wasn't a signatory.
Right. So I'm not disputing that formation questions generally or for the court under the FAA framework. The question is, what is necessary to find a jurisdictional fact under the FSIA? What is necessary to find a jurisdictional fact? And my submission would be that when a party chooses to arbitrate the issue without reservation, they never said, arbitral panel, you cannot raise this, you cannot decide this issue.
They said it within the arbitration.
They said that they raised their intra-EU objection, but they raised no objection to the delegation of that precise question to the tribunal. Far from it, they invited the tribunal to decide it. So this is different from other cases where the jurisdictional fact has not been passed upon before. This is one that Spain invited the arbitrators to decide, and now it wants a second bite at the apple in enforcement courts.
Does that have to be a factual, I guess, finding by the arbitral tribunal to work?
So the way I was thinking of it, Judge Pan, is that it would also apply to mixed questions of law and fact, but this is, I'm just using the court's terminology of the existence of an arbitration agreement as a jurisdictional fact. And that question clearly was litigated before the tribunal at Spain's invitation. And now they want a different result in this court.
So you're saying even if we're responsible for determining contract formation, we can just adopt what the tribunal said if the parties agreed that that's.
I am not saying that as a matter of arbitration law generally. I'm saying that with respect to the very precise and narrow question of what is sufficient to demonstrate a jurisdictional fact to obtain jurisdiction under the FSIA. And I'm not aware of any case that says you cannot conclude a jurisdictional fact from a prior litigation in which you voluntarily participated and indeed invited.
Arbitration.
Or a litigation for that matter, but in this case, it was an arbitration.
I have a choice of law question for you. So the New York Convention authorizes national courts to decline to enforce an arbitral award if the arbitral award if the agreement, was not valid under the law to which the parties have subjected it, or if there's no indication about that under the law of the situs of the arbitration itself. And so that's on the merits. We have choice of law spelled out in the New York Convention. And I guess in evaluating whether there's an agreement in the first place, do we use that same choice of law analysis?
I think
really at the bottom, I'm trying to figure out.
No, I would think not, Your Honor. I would think that under the FSI, because you're interpreting the FSIA here. So I would think that the question of whether there is an agreement to arbitrate would be one that would be decided under federal law.
Well, under the FAA, we look to state law because it's a contract question. So under the FSIA, in terms of the contract law, that would apply.
Well,
what is the analogous, to the extent that there's the same kind of question?
Well, then I think you would look to the Energy Charter Treaty itself, because that is the document under which arbitration was conducted here. And Article 26.6 says that you interpret the Energy Charter Treaty in accordance with its terms and international law. So the question of whether there is an agreement, I suppose, would fold back onto one of international law, but I don't see that as, there's no dispute that the Energy Charter Treaty exists. So if you take my frontline argument that that is sufficient to establish subject matter jurisdiction, then.
Okay, and Spain has an argument that the Energy Charter Treaty means something different than what you think it means.
Yes.
And if that's a question about the nature of an agreement, I understand that we look first to the text, we look to international law, but international law doesn't typically have a lot of contract law in it.
So let me take,
Nor is even EU law. For that.
This goes straight to the merits of Spain's argument. And so let me just address the merits analysis here. I would start first with the United States' submission that at least some deference is due to the arbitrator's conclusion here. And second, Spain has raised this argument before 30 different arbitral tribunals against it, and it has lost every one. It has lost this argument, indeed, with 28 of its own appointed arbitrators voting against it. So it's asking this court to be really an outlier.
Except that, Ms. Harris will say, every court to look at this issue, every court agrees with the EU.
That's but that's simply not true. The UK certainly does not agree. The UK held
Right,
that
every
this
court in the EU.
well, even that is of quite recent vintage. It is simply not true that the EU member states have always understood this to be the case since the founding of the Energy Charter Treaty in 1994. I would point to Joint Appendix 398. This is the jurisdictional decision in this case, which is from 2014. And there it is addressing the commission's amicus brief in what it was the Achmea case. It's called Eureka, but that's Achmea. And it says, what is more, the views expressed by the European Commission are not shared by the majority of EU member states, who in fact have expressed different views on this matter. Suffice it to say that the stance taken by the Dutch government in the same Eureka case, in which the Dutch government, taking a diametrically opposed position as the one held by the Commission, supported jurisdiction of the tribunal. It is not true that all EU member states always understood that they were not allowed to arbitrate under EU law. You raised a question, Judge Pillard, that I think it's important to address, that but what importance does it have to non-EU members? The importance is that if arbitration is unavailable within the EU, then EU member states have an incentive to choose EU-based investors over non-EU-based investors who could invoke arbitration. That is why it has to be horizontally fair.
And all the EU investors will go overseas, and all the overseas investors
Right.
will go to the EU.
I would add that the implications of Spain's argument are quite stunning. It would mean that any decision of the Court of Justice for the European Union could alter the treaty obligations of all EU member states for any number of treaties. The New York Convention, ICSID, just a decision of the EU, the Court of Justice for the EU would just take the entire European Union out of these treaties, which is of course contrary to the terms of those treaties, which provide methods for amending them, methods for withdrawing from them, methods for modifying them.
I wonder, you pointed to, an earlier time, I think it was 2014, when there wasn't the kind of consensus that seems to be emerging today within the EU. And we were discussing earlier this morning, Article 46 of the Vienna Convention, under which a state may not invoke its internal law and it's being applied to the EU, may not invoke EU law as invalidating its consent to a treaty unless the violation is manifest and concerns a rule of internal law of fundamental importance. Example in the briefing was if, the president tries to sign a treaty and doesn't have Senate consent, it would be manifest to the world that that was not binding. And so, and I guess my question is, given the coalescence now of the EU, do you have a view on whether moving forward the Vienna Convention at some point precludes EU investors from relying on the ECT to form arbitration agreements with Spain?
Well, first of all, I think that would be a different argument than the one Spain is making. Spain's not saying that it has permission under the Vienna Convention to abrogate it. It's saying that it never meant what it said.
Right, but I'm saying as their view coalesces, I'm trying to appreciate, what wiggle room other than rewriting the treaties.
The EU is en masse in withdrawing from the Energy Charter Treaty, and that is its remedy. If it wants to actually remedy it today, it can get the other member states to agree to the modification that it says has always existed.
And my question is really, is there a way under the Vienna Convention that occurs without a sort of positive treaty?
I'm not aware of any I'm not aware of the Article 46 case law that would permit or would foreclose that possibility.
On the injunction, are you still seeking an anti-suit injunction against Spain?
No, so the It's, so as the court is aware, the district court denied our motion for motion for preliminary injunctive relief as moot because it found no subject matter jurisdiction. Since the primary briefing on this appeal concluded, Spain has withdrawn its request for anti-suit relief against us in the Netherlands. And that makes sense because we're now a Delaware entity. So we don't have an anti-suit issue at this point anymore. I do want to address the fundamental basis for the district court's decision below here, which was that under Article 26, paragraph 6 of the treaty, EU law is international law that supervenes and alters the meaning of the Energy Charter Treaty itself. That is not correct. If it were correct that EU law could modify the meaning of the treaty, so could any bilateral investment treaty between two member states. That is obviously not what the members of the Energy Charter Treaty signed up to address. Instead, I would point this court to Medellin versus Texas, the Supreme Court's decision in that case, where it says that even if the treaty violates US law, that means that the treaty cannot operate within the US. It does not mean that the United States does not have obligations within the international law domain. EU law operates within its own domain. It operates on that plane alone. It does not change the meaning or content of international law that in a treaty that governs not just the EU and its member states, but 56 different member states. If there are no further questions, I hope I reserved a little bit of time for rebuttal as I requested.
You requested 3 minutes?
I did.
Do my colleagues have further questions? Thank you.
Thank you.
Mr. McGill, and we will hear again from Ms. Harris for Spain.
Thank you, and may it please the court, Sarah Harris for the Kingdom of Spain. I'd just like to briefly touch on 3 points that Blasket addressed. First of all, it doesn't matter how you view the Energy Charter or the putative agreement, however you slice or dice it, even if you thought that the Energy Charter Treaty itself was somehow an agreement to arbitrate among the members, Spain couldn't and didn't consent with other EU members to arbitrate. Now, the other side seems to assume that agreeing with anyone is good enough to agree with everyone. But notably, their answer to the hypothetical of North Korea appeared to be, don't worry about that. Arbitrators are smart and we'll deal with that on the back end. That is not a satisfying answer, either with respect to the sort of this court's precedents saying that whether you agreed with someone or not is a fundamental question of formation, or other circuits cases. And I would specifically point to the Lloyd's decision from the 11th Circuit, the Al-Qarqani decision from the 5th Circuit. Both of those cases also involve fact patterns where the question is, did someone form an agreement with someone else? Yes, there might be an agreement with one person, but not the person who's relevant to the consent. So, you can't just sort of say, oh, well, agreeing with everyone would be enough. And anyway, as the United States has pointed out, it would be pretty strange to think that the Energy Charter itself is sort of a self-encompassing agreement to arbitrate among member states, given that the text of the Foreign Sovereign Immunities Act, Arbitration Act exception, refers to the parties having an agreement to arbitrate. The parties clearly are talking about like the people before the court trying to sue the foreign sovereign in US courts. Second of all,
So you do have the provision about the parties agreeing to arbitrate or on behalf of others.
yes, and so it's the second part that I'm focusing on. It's not just an agreement made by the foreign state with or for the benefit of a private party to submit to arbitrational differences. It's differences between the parties. So the parties here are investors and Spain. And I think that text shows that our interpretation has to be correct in terms of the relevance.
It seems like the FSIA, we've been talking about this all morning, but it seems like it pivots. It's a little inexact in its wording that the agreement between the parties something, or for the benefit of. And if the parties to the treaty are states of the nature of the beast, but for the benefit of are not states, and then the disagreement or the dispute between the parties, it appears that the FSIA is using parties in the later clause, describing parties to the dispute, not to be the same parties as the parties to the treaty.
But I think the better view of the FSIA is it's more naturally talking about the people actually before the US court. So you could have a potential agreement maybe for the benefit of third parties, but the parties are actually talking about like have to have some sort of consent. And I think that also just more.
So what is your sort of classic case that you think the for the benefit of is referencing?
I think for the benefit of, you could have
That beneficiary arbitrate under that agreement or no?
I mean, let's say you had like, I think the person would probably have to have consented because otherwise they are not actually agreeing to arbitrate at all. Like they could be hailed before, they could be subjected to arbitration they didn't agree to, would be kind of strange. I think this just tracks the nature of the Foreign Sovereign Immunities Act itself, the idea that foreign sovereigns actually have to have consented to be in like US courts in a pretty clear way, or have done through their conduct that sort of consent. Anyway, regardless, just looking at the Energy Charter Treaty one way or another, the baseline concern remains. Under the other side's view, they seem to think that everything reduces to a question of scope that is always arbitrable. I'm not sure what would remain of this court's decision in Belize, at this court's decision in Micula, even the distinction drawn in Stillix itself, their case that they rely on over and over again. It would make no sense for this court to have said, wait a minute, Moldova's argument is not really an argument about the formation of an agreement. What they're trying to do there is backdoor a question of scope. Was this an investment or not? To try to say, oh, we didn't agree to that type of dispute, but we agreed to this one. Everyone agreed there, because there's no issue of intra-EU issues with the parties there, that there was some sort of agreement. Again, the only question was, did they agree to this particular investment or not? And that is what the Supreme Court has said the dividing line is in the domestic arbitration context in cases like Buckeye. And that's what this court has done in the Foreign Sovereign Immunities Act context. So again, it would be really hard to explain what this court has actually done in Foreign Sovereign Immunities Act cases if it just didn't matter. And if all you could do is say any sort of dispute over who can sign an agreement or whether they had the power to do so always reverts to arbitrability. Just look what the arbitrator did and we're done here. Third of all, just the view that you should look at the arbitrator's win-loss record and the votes for investors as somehow probative of what treaties mean is a crazy way to review to understand what treaties mean. Certainly not the way the Supreme Court or this court has ever interpreted a treaty, and not a good road to go down. What a treaty means is a matter of both text and signatories' understandings, and this is not a question for the EU treaties of some sort of national law, like the sort of Belize Constitution at issue in Belize. This is international law. It is the stuff of treaties between EU members. Now, of course, it doesn't govern relations between non-EU members, but between EU members, investors included, that is the supreme law above all in international law. And that is what the investors should have known as the sort of clearest rule of the EU system for all time. And so the idea that you should discount how the treaty signatories have understood the Energy Charter Treaty, again, there is no principle of or case law that would suggest you throw the signatories' understandings out the window because they're at this point in time versus the other one.
Is your position that the Vienna Convention Article 46(1) condition has been met since this investment was made, or the provision allowing saying that internal law here, internal EU law invalidates consent to enter a treaty because it was manifest and concerned a rule of the EU's internal law of fundamental importance? You mentioned that this morning, and
So our fundamental position is that rule doesn't even apply because it involves internal law. EU law is emphatically international law, and that is talking about domestic.
It's really both.
Yes, and their position discounts the key thing, which is if it's international law, you look at other treaty conflict rules under which I think we clearly win, however you apply the other Vienna Convention rules. And look, I think we would say even if you wanted to apply the internal law rule, we could satisfy it, but I don't think that's the right way of looking at it. Because again, the relevant conflict rules first and foremost should be the specific governing the general or the EU primacy principle, which is you have a dispute. One hand is an EU member, on the other hand is an EU national. The order of priority under international law as set forth in the EU treaties is specifically that EU law takes precedence first and foremost over other international agreements. And again, if you want to look for notice of that, that is not some sort of principle that just emerged recently. There are a ton of European Court of Justice decisions establishing that like way, way, way before these investors even stepped foot in trying to invest.
And I have the same question for you that I had for Mr. McGill about choice of law. The New York Convention says national courts should evaluate the validity of an arbitration agreement under the law the parties have agreed to, or barring that under the law of the situs of the arbitration. Do you agree that that provision also should govern our choice of law analysis for purpose of the threshold FSIA question, or no?
We think that what governs first and foremost would still be EU law. That is the law first and foremost that these parties.
So we apply different choice of law analysis to the same question when it arises under the FSIA as a jurisdictional question than we would in the merits.
You might, but let me just sort of back up and say, I don't think it matters in this case because first of all, I think the relevant choice of law question is, did Spain have the power to agree to the agreement under the FSIA? I think that's your first point of decision because you're asking, is there an agreement? And so under the FSIA inquiry, your question would be, what law tells me if Spain had the power to agree or not? We say first and foremost, EU law. I took Blasket's brief to be saying you apply different Vienna Convention principles, like look to, what's more specific, look to what's later in time. Our position is if you apply those conflict rules, we still win because again, the EU treaties are international law. They are more specific and also they are later in time given the re-ratification of the Treaty on the Functioning of the EU. So those seem to us to be the relevant rules that have been argued in the case that would apply to this specific question. Now, again, if we then pivoted to their other alternative, which is start off from the world where you look at the Energy Charter Treaty, we then just get back into all the arguments about what does it mean that the EU itself signed this treaty.
I think I asked you in the last case whether the EU Court of Justice cases actually spoke of Spain's incapacity as opposed to the invalidity of actions taken. And I'm not sure I heard a clear answer whether those are really properly understood as capacity questions.
Our position is yes, they are. And let me just give you some specific language. European foods, I think, is the clearest in just synthesizing the line of cases. And it talks about sort of consent, quote, lacking force. The German High Court's decision, Achmea 2, is also a good way of looking at this because it's obviously applying the relevant EU decisions and trying to figure out what does that mean in the posture of a court trying to figure out like what happens to confirming the award or not. And there the court said the agreement is, quote, void ab initio. That's the kind of language that means you didn't have an agreement at all, not some sort of enforceability argument. The other side's comparing this to preemption, and I think that's just the wrong analogy. This is much more like, do states that purport to enter into a treaty with Mexico, is that a treaty or not? No, it's not a treaty. States gave up the power to form treaties as part of the Constitutional Convention. And in terms of other—
That is not true with respect to the EU.
Respectfully, that actually, with respect to the EU treaties, what happened is Spain and other member states are saying they do not have the power anymore. They're giving it to the EU to have a system in which disputes are exclusively resolved by the European Court of Justice when they are between members and involve EU law. Spain will not submit, cannot submit disputes that implicate EU law other ways. And that sort of distinguishes the question we had earlier. What happens if Spain is in a forum against its will, trying to deal with questions of EU law? The obligation there isn't to sort of throw up Spain's hands and say, we no longer want to defend EU law. We no longer want the European Court of Justice's decisions to be bound. When Spain is in this forum, Spain is saying, apply European law. But the obligation is, don't try to circumvent the EU treaties that Spain agreed to follow as paramount law. don't try to do side deals, don't try to do side agreements. You can't do that as part of the price of being a member of the European Union, which is a really novel enterprise in this respect of shared sovereignty in the EU.
I have a sort of a practical question. What do you make of the arbitral panels uniformly or almost uniformly rejecting this view, including international law jurists chosen by Spain or other EU countries? I mean, this is this is not the kind of dispute we hear every day. So it's helpful to have bearings on some of these more practical questions. What's going on there in your view?
In our view, again, I can't speculate like what is motivating the arbitrators in these panels to say essentially like we think we can keep arbitrating because we don't want to pay attention to European Court of Justice law. I think the problem is on their side they're pointing to a lot of arbitrators' decisions, and on our side we're saying what you should be looking at is what the signatories understood and the way that the treaties play together. And I think you just can't credit like what a bunch of arbitrators are saying in like the framework for evaluating how you interpret treaties. That's just not one of the tools that people normally turn to ever as a matter of treaty interpretation. So no, I think you can say, yes,
those arbitrators, if they're presumptively acting in good faith and on their best reading of the law, they're looking at the same materials you're looking at.
Yes. And again, I think this shows like in the international community, there might be like among law professors and arbitrators disputes on these questions, but it would be really strange to say you credit those views over in a treaty that has a bunch of signatories over what the signatories themselves are understanding the treaty to be, especially because the US isn't a signatory to that. Like that's pretty disruptive to the treaty framework. If all of a sudden people who didn't expect to have intra-EU arbitration, who didn't see it under this treaty, even attempted until 2007, suddenly see, oh, well, what do we do with this? The European Court of Justice said this is not a thing, but we're supposed to defer to arbitrators. And supposed to sort of
defer. I'm just asking you for a sort of just a real world take on what universe are they operating in from your perspective?
I honestly
so alien.
And I really think it is just a dispute among international scholars over like what to do with EU law. But to me, the more salient point is, has this been a feature that the EU has done with treaties in the past? Yes. That is how the EU has approached other treaties like the WTO, the UN Convention on the Law of the Sea. Those are treaties like 1995, one of them. And so for this court to say, sorry, if the EU joined those treaties, doesn't matter. You should have known that you agreed to arbitrate under those as well, or had other dispute resolution outside the EU system. That's a real problem, both in terms of how those treaties currently operate and what signatories understand.
Did you argue about those treaties in your brief?
We argued about the WTO, and then the UN Convention on the Law of the Sea is a subject of the Ireland decision, which we do rely on extensively. It's from 2006.
Right.
So yes, those are important sort of context in terms of what people are thinking and what might happen and why Spain cares very strongly about the arguments here.
Thank you.
Thank you.
Questions? Ed Rogers? Great. Thank you very much, Ms. Harris.
Thank you. May it please the court, Sally Pay for the European Commission. I have just 3 points to make at this stage. The first is that EU law is absolutely international law, and I just wanted to make sure that there's no confusion about the European Commission's position on this point. It's well accepted that EU member states can enter into agreements regulating the relationships between present and future treaties, and that is precisely what they have done in the EU treaties. The relevant principle is that of primacy, and that's what governs the relationship between EU law and any contrary international agreements. And this is very important to the structure and the integrity of the EU legal order, because if the rule were otherwise, member states could simply enter into other international agreements that would undermine and circumvent EU law itself.
So if the EU came up with principles that were in variance with the Vienna Convention, those would be primary over the principles in the Vienna Convention, or in?
So we're discussing here an intra-EU situation. So
when you say primacy, it's like not only is it international law, but it's it's above all international law? I'm just having trouble understanding.
Yes, so EU law and the EU treaties have primacy over other international law as far as they, insofar as they are regulating intra-EU.
So that would be true of the
circumstances.
Vienna Convention.
That would be true of the Vienna Convention with respect to internal EU application of it. But that's the whole way that the European system has been constituted.
So what about your friend on the other side's hypothetical about NATO? What if the EU decided that it violates internal EU policy and norms for members to be in NATO? Would that just take them out of NATO?
Well, I think that in that case, there would be potentially a question about the rights and obligations of third parties that are not EU member states to the NATO agreement. And so just to be clear, the primacy of EU law is with respect to the international obligations owed to between member states.
But I guess under the ECT, you agreed in a multilateral treaty, which included people not within the EU, that there would be this unconditional consent to arbitration. So isn't it like NATO in that respect, that you agreed in a multilateral international treaty
So
to do something?
With respect to the Energy Charter Treaty, yes, it has implications for relations outside the EU. And that is, in fact, that was the sole purpose of the Energy Charter Treaty. It was never intended to govern intra-EU relations. And so it's within those intra-EU relationships that EU law has primacy.
So I guess my question is, if the EU and EU countries agree to something in the context of an international multilateral treaty to do something that affects intra-EU relations, you're saying that they're not bound by those international treaty obligations, that they can trump it?
So I would put it instead by saying that when the EU and member states enter into a multilateral treaty, they are not creating obligations between themselves under the treaty. Instead, the rules that govern are EU law. So the EU's position on this is that the Energy Charter Treaty's substantive provisions do not have any effect with respect to intra-EU relations. So EU investors are supposed to bring actions if they think that they've been wronged by an EU member state. The remedies are in EU national courts under EU law causes
No,
of action.
I understand your position. I'm just trying to understand how that relates to your obligations under international, like multilateral treaties that involve parties that are not just within the EU.
Yes, and so with respect to parties that are outside the EU, there are obligations under the Energy Charter Treaty, and that's why non-EU member
No,
investors.
but I'm trying to sort of zero in on, if you commit in a international multilateral treaty to do things, including with respect to people within the EU, you think you can abrogate that? Like, just hypothetically, say you did commit to that within the ECT. You made commitments to people outside of the EU that you would do certain things, including within the EU. You think you can abrogate that based on EU law?
So I do think that EU law would have primacy within the EU if it's not affecting the rights of third countries or third country parties. The rule of primacy really is about the.
So what if it does affect the third party countries? Because there was an argument that it creates incentives for EU states to favor EU investors because you don't have to arbitrate with them.
So if we're talking about the rights of third countries or the rights of third country investors, those rights are valid and they are live within the treaty.
So what if your position contradicts the rights of these third party investors?
The primacy would not apply in that particular
it's-
situation.
Wouldn't, so it's not, I think what Judge Pan is arguing is arguably it's not fair and equal treatment as between potential within EU investors and foreign investors. They're coming to Spain to invest with different procedural recourse, and that itself might have implications to the non-EU parties.
Yeah, I think you just conceded that your position would not hold if it affects non-EU parties. And I gave you a hypothetical where it does. And you're saying then
Under this very treaty.
under this very treaty. And so now you're saying that EU law doesn't have primacy.
So I just want to make sure that I actually, that I am understanding the question that you're asking.
The issue is, I said, what if you make promises that affect people who are not within the EU in the context of this multilateral international treaty? And you've promised to do things under this treaty that do affect intra-EU relations, but that would affect the third parties. And you said then EU law wouldn't have primacy.
And so in this hypothetical, the parties that are trying to invoke the protections of the Energy Charter Treaty are the third country investors, or are they?
No, that what your friend on the other side said was that if your view is true, it does affect the non-EU members of the treaty because EU nations will favor EU investors because they don't have to arbitrate with them. So that is detrimental to all the other non-EU parties to the treaty. And so they're affected. And I believe you just said then EU law would not have primacy.
So I think that's not the kind of situation where we are talking, where that would be an issue of a right or obligation owed to third country investors under the Energy Charter Treaty itself.
So what's the answer to my hypothetical?
So under the hypothetical where you have an EU investor that is saying that that they should be.
No, I'm just saying as a general matter, EU primacy will hurt the members of the treaty who are not from the EU.
In a more attenuated sense than the idea that the EU and its member states have not, they must respect primacy as it applies within the European Union to intra-EU relations.
No, but
I can see that there are.
The focus of my question is why is it that the EU can abrogate terms of a treaty that affect people who are not within the EU? It's an international multilateral treaty.
So in terms of how it is affecting other member states that are or other members of that treaty that are not.
So you agree that they can't do that if it is affecting members who are not part of the treaty?
If it is affecting member states
that are not part of the EU.
So if it is going to affect the treaty rights and obligations owed to those member states, then primacy is not in the picture. But I don't understand your hypothetical to be a situation where the EU rules would be affecting the rights and obligations owed under the treaty.
I'm just trying to get to a basic premise, which I think you agree with, which is that if the EU has obligations under an international multilateral treaty, it cannot unilaterally abrogate them.
Yes, I think that's correct.
Okay.
All right. Moving on to the second point that I wanted to make at this stage is just really about this theme of unfair surprise and unfairness to the investors here. The notion that the investors are somehow being treated unfairly and have been surprised by developments in the EU is a false narrative for at least three reasons. First of all, I think it's important to recognize that intra-EU investor-state arbitration is a very recent phenomenon. The first intra-EU bilateral investment treaty case was brought in 2005, and the first intra-EU Energy Charter Treaty case was brought in 2007. That's a case called Electrabel versus Hungary. And so when these cases started emerging, the Commission acted immediately to raise questions about at least a potential incompatibility between this type of dispute resolution and the EU treaties. And you can see references to some of those statements at page 477 of the Blasket Joint Appendix. That's in Spain's Hindelang Declaration. Regardless, at least as early as 2006, and that's already 5 years before any of the investors in these cases attempted to invoke Article 26, investors would have been aware and on notice of the potential incompatibility between intra-EU arbitration and EU law, even based on the jurisprudence of the Court of Justice. That's the Mox plant case involving Ireland, where the Court of Justice held that Ireland had breached the EU treaties by initiating arbitration under the UN Convention on the Law of the Sea against the United Kingdom, which of course at that point in time was an EU member state. And so EU investors should have been on notice of the content of the decisions of the EU's highest court on this matter. And finally, there's just the basic point that Achmea and Comstroy, while they are, of course, decisions of more recent vintage, they were applying principles that flow from the EU treaties themselves that have been enshrined in those instruments for many decades. And of course, also the decisions of the Court of Justice are retroactive, much in the same way as when a US court issues a decision about the meaning of the statute, it is saying what the statute means and what it always meant. So
Ask you about, I mean, I really, this is kind of all new to me, all this EU law. I'm trying to understand the incentives of the EU in this case. It seems like the EU has an interest in, I guess, keeping the financial assets of its member states within the government. Isn't that the whole point of this? It's a state subsidy argument. It's like, I'm just trying to understand why the EU thinks it's important that things be ruled on the way you say. And I don't see the importance of uniformity in laws because it's not precedential. And I'm wondering if there's some other motivating reason for the EU to be here. And isn't it in the EU's interests to allow these EU member states to avoid paying these judgments because it keeps the money with the governments, which is better for the EU than letting it go to private parties that are energy companies and other investors?
So I don't think that the issue for the EU is exactly keeping money within the governments. For the Commission, the question really is one of its exclusive competence to regulate state aid within the EU. State aid is a principle that under which governments cannot provide subsidies to businesses or companies operating in the EU
Isn't that one of the premises of the ECT though? Like to encourage investment, they were giving deals to people to come in.
But only with respect to to investors who are outside the European Union. The Energy Charter
Putting
Treaty.
aside to who? The ECT was to encourage investment and that included incentives.
Correct, but it was never intended to apply with respect to intra-EU investors. It was never intended to create rights to EU people already within the EU.
So why would the EU enter the ECT if the purpose of it was to provide this state aid that's not authorized?
So it was in order to extend the EU's energy policy beyond the EU's borders. So it was creating sort of a framework that would essentially try to encourage members, non-member states who eventually might accede to the Union to bring their legal protection, their laws in line with the EU's internal policy. So it was never intended to authorize the granting of state aid.
Can you explain that? Like what was supposed to happen from the EU's perspective?
So from the EU's
if they sign the ECT, it's going to do what? It's going to encourage non-EU nations to join the EU?
That was part of the picture. So in the 1990s, this is when the Energy Charter Treaty was negotiated. The idea was that already within the EU, there were certain, there was an existing energy policy and investment protection for EU investors. And the EU wished to try to extend some of those policies outside the EU. And the way to do that was by negotiating an agreement with countries that were not part of the EU.
But I thought you said that the investment protections were unlawful state aid. So you're saying
there were different pre-existing protections?
There are different rules that govern investment protection within the European Union. And the Energy Charter Treaty was simply never intended to supplant or displace those. And so going back to the question of state aid, the reason why the Commission is so concerned about these awards is that an enforcement court outside the EU, or for that matter within the EU, does not have the ability or competence to order a state to provide aid. Subsidies can only be paid to investors if the Commission has specifically authorized that. And the Commission has not authorized to date the payment of these awards. So from the Commission's perspective, it's very important that
So it's not really the judgments that are unlawful. It's the fact that your EU members ever gave any of these investment incentives. They weren't allowed to do that, but they did it. Now the investors are trying to collect on what was promised to them. And you're saying they never were allowed to do that to begin with?
So it is both, to the extent that that EU member states, such as Spain, but also other countries, to the extent that they offered and paid subsidies to EU or other to companies without first getting approval from the commission, that is unlawful state aid.
And do you think they believe the ECT was the permission?
That the investors believed the ECT was permission?
That Spain did?
I don't know what Spain believed at that point. I think Spain should have been on notice of its obligations under EU state aid law to notify the
But
commission.
it did a lot of this.
It did a lot of the payment of
The
subsidies.
Giving of subsidies.
Yes, and the commission's position is that Spain should not have done that without first notifying the commission and obtaining permission to do so.
And it's not state aid if you pay a subsidy to a non-EU investor?
It also may be a question of state aid in that respect. The identity of the beneficiary of the aid is not dispositive of the state aid analysis. It's really whether the payment of an amount would potentially cause distortion of competition within.
Then why can Spain pay subsidies to non-EU people? It still, does not still violate the state aid, I guess, doctrine?
So the question of, I think the commission's position is that there are state aid implications also for non-EU investors investing in the EU. They also should be on notice of the content of EU law and should be. And
Then I just don't understand the divide that you're drawing between EU and non-EU investors.
so when
Is it that the ECT, as you read it and as Spain reads it, was EU authorization, notice and authorization for state aid to non-EU investors? And the mistake was Spain extending that to EU investors?
So I don't think that the commission would agree that the ECT itself constitutes authorization to pay state aid. There needs to be a formal process by which the member state notifies the commission of its intent to pay and receives a decision. And just going back to Judge Pan's question about.
Then why isn't your position that Spain didn't have the authority to enter any of these investment decisions within EU or external to EU investors because it's state aid?
So I think the state aid analysis would need to, if there's an award against Spain that's been obtained by an EU investor, I think there would still need to be a state aid investigation and analysis of whether Spain can
But
actually.
why
do
not
that.
for the non-EU?
I think there would also need to be an analysis of that because the state aid.
Then why are these awards enforceable as to non-EU investors but not EU investors?
At least as far as the Court of Justice has left the question, and it has not yet definitively ruled on the scope of the principles in as far as they apply to third country investors. But there is the court has left that open. But it would be something that the court would need to address in the future.
Yeah, I'm just confused by the EU's position because it just doesn't seem like, I don't understand we're trying to keep the cases in alignment because these have no precedential value. And now I don't understand it's important for EU order because of state aid, et cetera, because there's no reason to distinguish between intra-EU and outside of EU investors. Like,
Yes.
your position, I don't understand the reasons for your position.
Yeah, so I'm sorry about the confusion. I mean, I think that the fundamental point here is that the commission is the union's state aid regulator, and it has an interest in making sure that its ability to evaluate and decide on these questions of state aid, whether they pertain to, especially where they pertain to EU investors, where the law seems to have been focused, but also in future cases, that it's important that the EU Commission be the party that is able to exercise its obligations and its regulatory mandate that flow from the EU treaties itself.
It just seems that also your interests can be vindicated by allowing these proceedings to happen and then moving for a stay of any execution of the judgment in the United States, and then proceeding with what you're doing already, which is determining whether Spain is allowed to pay any of these judgments.
So I think with respect to that, there are a couple of problems. First of all, the mere idea of a body other than the European Commission authorizing or ordering an EU member state to pay aid is problematic from the perspective of the Commission's exclusive authority in this area. With respect to what should happen in the hypothetical world in which these awards are permitted to be enforced, there would be a complicated cascade of litigation and other proceedings that would need to happen in the EU. So say, for example, Spain were to pay in compliance with a US order, or say even that Spain had some of its assets attached in execution.
No, my thought was, say that's all stayed pending whatever you all decide about what Spain can do. What would happen?
So, then the EU would still be, I think the basic point about another entity having ordered the payment of aid, I think that is still fundamentally a problem for the Commission, and one that it would it takes strong issue with. But I also, to your point, that if further proceedings were to be stayed, the practical consequences might not be the same, but I just wanted to lay out for the court some of the practical consequences and what they would be. Because if Spain were actually to pay anything, the Commission would be required to order it to recover and claw back any such amounts. A recovery decision itself would be in principle subject to further challenge and appeal within the EU system. And that, I think you can take a look at the Micula decision and that case as an example of the very complicated machinations that result from a state actually paying or being made to pay an award that is indisputably unenforceable within the EU as a matter of both EU law and impermissible state aid.
Well,
So-
I thought that the EU is deciding whether or not it's permissible.
Correct, but unless and until the Commission actually issues a decision authorizing, it is impermissible to pay.
It puts Spain in a difficult position because assuming that their assets in the United States are seized to pay the judgment, then within the EU, they would be required to claw back those assets
Correct.
through more litigation against the petitioners in this case, or the investors in this case.
Correct, and unfortunately, that is the bind that Spain would find itself in, and that's the Commission does not really have discretion not to order recovery, and I think that's again highlighting why Spain actually went to the courts.
So what are the proceedings going on to decide whether or not Spain can pay these judgments or not? Like, how does that work?
So Spain has notified the EU, the Commission, of these awards, and just I think this goes back to an earlier question you had about what is the aid here. The aid, it's not only the original subsidies, but the court has also held that the payment of and the Commission understands that the payment of an award itself would constitute aid. So Spain has notified the awards to the Commission. The Commission is reviewing those. While it is reviewing, it is impermissible and unlawful for Spain to pay anything. That's
So
the
does the
standstill
EU just have
obligation.
discretion to say you can pay these awards?
It would. There are laws on factors for when it would be permissible to pay state aid. I think, given the way that the Commission's decisions and the court's jurisprudence has developed on this point, I think probably it would be quite unlikely that these awards could be paid, just based on the way that the principles have been developing. And I also would point out that there is no principle of state aid law under which an order from a national court, whether it's in the EU or outside the EU, would be a reason to excuse Spain from a recovery obligation. So again, I think that simply is to underscore the complicated questions that are posed by these particular awards and the notion
Can
that
this all be settled? Can the EU and Spain and these investors all get into a room and just settle this?
In terms of settlement, I think that too, and once again, this all comes back to state aid. I think that too could pose some serious questions. I don't know what the contours of all of those would be, but
I'm just wondering, can the EU does it have authority to enter settlement negotiations along with Spain and these investors and just work this out?
In terms of the authority, I don't know for sure the answer to that question, but
because I guess the EU could come to the table and say, well, we'd be willing to waive or I guess allow payment of this much as state aid as part of the settlement and withdraw the clawback requirements, et
under ex-
cetera? Or I
Under,
just-
under existing state aid law, I don't know whether that would actually be possible, given the content of state aid law as it stands. I mean, whether the law would be or could be amended. I mean, I think that then we are really straying into
I'm
things that
only
are, yeah.
asking because it just seems like I'm not an expert on international law, but this case cries out for settlement, just looking at just the complexities involved and the different.
I agree with you
issues.
about the very high degree of complexity of this case. And I think that really underscores why, again, it would be extraordinary for, I think, this court to take the bold step that the investors are inviting, particularly given that the United States is not a party to the Energy Charter Treaty. There's no
So
particular
what's the bold
interest.
step we're talking about?
The bold step of allowing the enforcement of these awards and seeking an anti-suit injunction. I understand that Blasket is no longer seeking an anti-suit injunction, but enjoining a foreign sovereign and preventing the European Commission from being able to enforce and carry out its regulatory mandate under the state aid regime.
But it's not extraordinary to just enforce an award under the ICSID, which Spain is a party to. That's an extraordinary.
Well,
I understand the injunction.
Why
might be.
is it a bold step, especially in this case, where if it continues in the district court, the court will have a chance, that there are more bases under the New York Convention to hold that an award's invalid on its merits, even if jurisdiction is recognized. So what would be bold about allowing this to go forward and have the arguments about validity or not be vetted before the court?
So I think that the court still needs to, even before you get to the questions about the merits and whether enforcement could be permitted or not under the New York Convention, there's still, of course, the threshold jurisdictional question of whether there is an arbitration agreement. And here, where the Court of Justice has spoken, has reached that conclusion based on longstanding principles of EU law. And these are principles also that are fundamental to the EU legal order. And where, I think that if you are choosing between two positions and two interpretations of this treaty language, one of which is consistent with the views of the European courts and every relevant sovereign here, including the home countries of the investors. If you're choosing between that and on the other hand, an interpretation that would go against that uniform consensus, that would open the door to all sorts of disruption within the European Union, I think there is a role for deference here.
You don't think Stillex effectively and Chevron effectively require us to hold that there's jurisdiction?
I don't. I think that those cases in none of those cases was there a dispute about whether there was an arbitration agreement. Nobody was arguing that there hadn't been an offer made, and that the offer was not to that there hadn't been an agreement created between the people who were trying to arbitrate. And now here, that the question is fundamentally different. It's a question whether Spain actually could ever have entered into an agreement with these people, with these parties.
Stillex said the treaty, the award, the ECT, the award, and the ICSID. Is it ICSID or New York Convention?
I think it was a New York Convention
Yeah.
case, but
So there's the ECT was the agreement to arbitrate in that case.
well, I think bear in mind that Stillex, of course, was not an intra-EU case, so there was no argument being made there that Moldova did not have the power to agree to arbitrate the dispute with the relevant investor.
No, but the move was that you don't have to get into Moldova and the investor, the intent there, the agreement to arbitrate there, because the ECT was itself.
So I think that in the Stillex case, there was in fact, there was an offer and it had been accepted by the investor, and that's simply not what the argument is here. I think it's the question there was the scope of the dispute that was being submitted to arbitration and whether the investment that was being sued about was an investment that was covered by the treaty. And that, again, I think is a fundamentally different question from the one that we're facing here about whether there was ever an ability on the part of Spain sovereign to agree to this, to arbitrate with an intra-EU investor.
Can I ask you, I guess it was represented to us that this argument that you're making or Spain has made has been run up the flagpole in a bunch of different arbitration settings and has been shot down. And so I'm just wondering, those awards, have they been paid and have you been trying to claw them back, or what has happened in those 30 other?
So in those other cases, I mean, I think the position is probably similar with respect to the Spanish awards. I don't believe that Spain has actually paid any of them yet because of the state aid implications. And the commission will need to evaluate and issue its decision about whether or not the awards can be paid.
Right. So that it's not extraordinary then, because 30 other awards are out there.
But they haven't been enforced.
Oh, you mean they haven't been confirmed?
Yes, that's correct. Yeah, I mean, I think these are the first three cases that have made it up to the Court of Appeals. And I think you raise a good point that there are multiple other cases involving these same kind of facts. I think there are probably about a dozen others in the district court at the moment. They implicate not just Spain, but there are cases against Italy as well. Cases also against, I think, Croatia and Poland. So this is not just an issue that's confined to the three cases that the court is hearing today.
I see. Thank you.
Court has no further questions. We thank the court for the opportunity to present the commission's views. Thank you.
Thank you very much.
I know it's been a long morning. If the court has questions, I'm welcome to answer them, but otherwise we would just rest on our briefs.
I had a question about, so the United States filed an amicus brief in the Nigeria case, Process and Industrial Development versus Republic of Nigeria. And you argued that it wasn't required that there be a valid arbitral award under the Foreign Sovereign Immunities Act because the New York Convention and its implementing legislation only require an arbitration award, not a valid one. And I wondered whether, here the question is whether there's a valid agreement, not a valid award. Does the same principle apply or no?
I don't think so, Your Honor. I think there does need to be an actual agreement to arbitrate formed as a precondition, whether to compel arbitration or to enforce a resulting award. I mean, I think the point is somewhat different, and I think it is consistent with and flows from the text of the FSIA as well, which provides for an action to confirm an award made pursuant to such an agreement to arbitrate. And, obviously under the New York Convention, the court retains the discretion to enforce an award that is no longer valid in the sense that it's been nullified, perhaps by a court of the primary jurisdiction. So I think that is the distinction we would rest on.
Thank you again for appearing at our request. Mr. McGill.
Big finish. There's been no answer presented to BG Group and its holding that there is an investment treaty, an already formed arbitration contract. That holding is the basis for Chevron's conclusion that the issue there in that case was a scope question to be addressed at the merits. Stylex, Chevron, and BG Group all dealt with challenges to the scope of consent. To be sure, this one comes in a little different packaging, but they all were about the scope of the state's consent. And in each case, this court and the Supreme Court held that those were arbitrability issues meant for the merits. Belize, Al-Qarqani, and Lloyd's, none of those cases involve investment treaties. They are instead bilateral commercial arbitration agreements, and that makes all the difference. If the Prime Minister of Belize didn't have authority to enter into an agreement at all, this bilateral treaty, then that is indication that there would be no agreement to arbitrate. That's not the case here. There is no dispute that Spain entered into the ECT and that it remains in force and effective, at least as to non-EU states. The EU itself, apparently the CJEU that is, does not view this as a capacity or formation problem. We heard Counsel for Spain say that this consent is, quote, lacking force or is void ab initio. Those are not formation issues. Those are validity issues under Buckeye check cashing. They are arbitrable. Judge Pillard, you asked about first options and the first option rule. I would point to the Second Circuit's case in Olin, where it's 73 F4th at 107, and it says there that the first options rule doesn't apply where Libya, quote, independently urged the tribunal to decide issues of arbitrability. That is exactly what happened here. The oddity here is that Spain is seeking a level of review at the jurisdictional phase that it cannot possibly obtain at the merits phase. That turns the whole purpose of the 1988 amendments on their head. It was supposed to streamline the path to enforcement, ensure that there was jurisdiction, not make it more difficult. On the merits here, of course, arbitration decisions are highly relevant to international law arbitration. What is going on here is an overwhelming consensus that EU law does not diminish member states' treaty commitments. It's an overwhelming consensus rejecting this idea of the primacy of EU law within the international law domain. Finally, on state aid, this court, of course, has an unflagging obligation to exercise subject matter jurisdiction where it exists, whatever the European Commission says about state aid. It also has, the United States has a treaty obligation to enforce awards. There's a statutory obligation of this court to enforce awards. And there's been no finding that the awards in our case are state aid at all. Thank you, Your Honors.
Thank you. The case is submitted. The next case, we have one more case. Thank you all.
Okay. Pick it up.
Case number 23-7008, Ioan Micula et al. Versus Government of Romania appellants. Mr. Fine for the appellant Government of Romania, Mr. Vasquez for the appellate Ioan Micula.
Good afternoon. We'll hear from you, Mr. Fine, whenever you're ready.
Thank you, Your Honor. May it please the court, my name is David Fine. I represent the government of Romania with my co-counsel, Ioana Saljeanu. Your Honor, may I reserve 2 minutes for rebuttal?
You may.
All right. Although I do recognize the clock has seemed to be fairly flexible this morning and this afternoon.
Welcome to our court.
I appreciate that. In order to avoid replowing the field, I'd like for the most part to rely on the argument that the Kingdom of Spain made in the previous 2 cases, particularly with respect to the effect of the January 25, 2022 order of the Grand Chamber of the Court of Justice of the European Union. Romania believes that Spain's position is correct. I will, however, note just a few points of distinction things that came up during the course of the argument that may or may not matter to the court, but that I think are important to note before going on to matters that are sort of Romania specific. The first is, of course, that this case involves a bilateral investment treaty, a BIT, between Romania and Sweden, rather than a much broader treaty that involves a great many more parties. Second, it was not commercial. It was an investment treaty. Third, the CJEU, that highest court in the EU, has expressly ruled in this case that the arbitration provision, but that Romania did not have capacity to consent to arbitrate by the time this proceeding began. And finally, I'll note that Romania has actually paid the arbitration award. There's some dispute raised by the Miculas about whether Romania has paid the full amount, but Romania believes that it has now paid, in fact, that full amount. Now, with the court's permission, I'd like to focus on two regards in which Romania's situation requires further discussion on top of the Kingdom of Spain's position. 2 points that the district court thought were relevant points of distinction. The first point was that the district court held that it was material that Romania entered into the BIT with Sweden in 2002, that the Miculas demanded arbitration under that agreement in July of 2005, but that Romania formally acceded to the European Union in 2007. That fact, those sets of facts, are immaterial. And they're immaterial for two reasons. First, once Romania signed the EU's act of accession, which it did in April of 2005, Romania was bound to follow EU law. And that proceeded by several months. Romania, the demand for arbitration by the Miculas. And as you've heard in the previous two cases, the proper analysis, and we ascribe to this, Romania ascribes to this, is that the BIT itself was not an arbitration agreement. The BIT was an invitation to arbitration, and the Miculas would accept that when they made their demand for arbitration. They accepted the demand for arbitration after Romania was bound to follow EU law because it had signed the act of accession. The other point is that even if the court regards the formal accession of Romania to the EU on January 1st, 2007 as the key date, we know that, number one, the arbitration panel said that certain of the damages alleged by the Miculas occurred after that date. And we also know that the award by the arbitrators was after that date. And that award was effectively ultra vires because there was no properly formed arbitration agreement.
Mr. Fine, you're arguing as if this were all before us, in the first time around, but we're viewing this all through the Rule 60 lens. And so it would be helpful if you'd focus on the Rule 60 arguments. For example, under Rule 60b-4, is it your argument that the district court's jurisdictional analysis was wrong from the start, or that even if it was correct at the time, it was rendered incorrect by the CJEU's decisions in European foods?
Thank you, Your Honor. The answer is that the decision was wrong ab initio when it was made in 2019, and the judgment was entered to enforce the arbitration award. It was made particularly clear after the CJEU decisions in January and then later in 2022, in which that body, charged with interpreting European law or EU law, said that this particular agreement and the language that the court used was, pardon me while I find it, the court held that the system of judicial remedies provided for by the EU and FEU treaties replaced that arbitration procedure and the consent given to that effect by Romania from that time onwards.
Don't you have to show that there was not even an arguable basis for jurisdiction from the original?
Your Honor, I'm sorry, Your Honor, I didn't mean to interrupt you. No, Your Honor, I don't think that I do, although I could. The reason I don't think that I need to is because I think that Judge Mehta erred and should have applied the de novo standard of review. If you look at this court's opinion and, in fact, Judge Rogers' decision in Bell Helicopter.
Isn't Bell Helicopter distinguishable because that was a default judgment proceeding? So the country didn't have a chance to raise any arguments at all, which is different here.
Well, that is a distinction, but for our purposes, I don't think it's a meaningful distinction.
Well,
Because-
did Romania agree that there was jurisdiction the first time around?
I'm sorry?
I thought Romania agreed that there was jurisdiction.
No, Romania, when it answered the petition after service issues are finally resolved in the district court in the confirmation proceeding, Romania raised the arbitration question under the ACMA decision.
No, I'm saying the original judgment.
That's what I'm talking about, Your Honor. On November,
Before ACMA.
no.
Okay.
No, it respectfully, it was not. But let me go back to Bell Helicopter. You have a look of inquisition on your face, Your Honor.
Many, but we'll have, go ahead, go back to Bell Helicopter.
Thank you, Your Honor. In Bell Helicopter, the court spoke about the court said that there is an arguable basis determination and standard of review, but there's an exception when the issue is sovereign immunity. And that's Judge Rogers' decision. And this is, of course, an issue of sovereign immunity. And so therefore, we believe that the court should be applying, the district court should have applied the de novo standard of review and revisited entirely the question of that court's jurisdiction under the FSIA. Now, even if there were an arguable basis evaluation, Your Honor, I think that Romania still has a strong argument, but I don't think that we have to go there.
But haven't we already decided this issue? I mean, we decided a few years ago in Micula 3 that because Romania didn't join the EU until after the underlying events, arbitration agreement applied. So why isn't, I mean, the district court followed that.
Right.
What's giving you the basis under Rule 60B?
Under Rule 60B4, the original judgment was void. And the reason why this court's earlier...
Right, go ahead.
I know you'd like me to talk about the earlier decision. That's what I'll do, I promise, Your Honor. And that is that at that time, there was not a decision in the case of the Miculas and Romania from the CJEU that definitively said for purposes of EU law that it was improper state aid and that Romania did not have capacity to consent to arbitrate with the Miculas. That was a new fact that was not before this court and that had not previously been before the district court. And those are, in fact, important points. Now, Your Honor, just to go back, the pinpoint site, by the way, for Bell Helicopter and the point about sovereign immunity being an exception to the arguable basis point. And this was wholly apart from whether the party had or had not appeared. Obviously, in Bell Helicopter, the Republic of Iran had not appeared, but the language of the court was that the arguable basis standard generally applied if the movement had appeared in the earlier action. However, quote, an exception exists where the issue of the waiver of sovereign immunity is at issue, and at issue is my own language. So I think that this is a different.
You said you were going to have the pin site. You're at
1182, Your Honor, in the Bell Helicopter decision. And the Bell Helicopter decision is also important for another point. And that is that Bell Helicopter tells us that judgments in excess of subject matter jurisdiction are not voidable, but simply void. And that's at 1180 in that opinion. And that's exactly the case here. The judgment of the court here, recall, of course, that the FSIA starts with a presumption of immunity, and you have to overcome it by proving the existence of an exception. And here, the only exception relied upon was the arbitration exception. And we now know from the CJEU that the arbitration provision was void ab initio. And in fact, there was no arbitration agreement formed because Romania did not have capacity to do so. It could not give consent by the time the Miculas began. Under Bell Helicopter.
Sorry, it
Yes,
does
Your Honor.
appear that Micula conceded that there was jurisdiction under FSIA when it appealed the prior judgment. It's at 805 Federal Appendix at 1. As Romania now agrees, the district court properly invoked the FSIA exemption for actions to enforce arbitration awards. So you conceded that, which makes you different from Bell Helicopter, for sure.
Well, it is a different circumstance. And there are two answers I would give to that, Your Honor.
It's also in your brief, JA 1828. The district court had subject matter jurisdiction over Micula's petition to confirm the arbitration.
I understand that, Your Honor.
1605A6.
I understand that. Of course, it's subject matter jurisdiction, and subject matter jurisdiction cannot be waived. There were, to be candid with the court, certain political considerations that underlay the determination not to pursue that particular issue. But the bottom line is that Romania raised the issue of FSIA immunity and the failure of the arbitration provision before the district court in that original proceeding. It's docket number 51, and its response to the Micula's petition for enforcement.
I mean, I just think that this does distinguish you from Bell Helicopter, and you conceded that there was jurisdiction on appeal, and we're in a Rule 60B situation here.
I understand that, Your Honor. And again, I don't think that a party can concede subject matter jurisdiction in the federal courts.
But it affects the standard of review that distinguishes this from Bell Helicopter.
Well,
You have to show an arguable basis.
Your Honor, I don't think on that regard it does, in fact, distinguish Bell Helicopter. And Your Honor, may I go ahead? I'm sorry. I know I'm talking over the clock here. I want to answer Judge Pants.
Back on the question about, why our prior decision isn't binding. You mentioned the subsequent CJEU decision. So that's what you're relying on.
Yes, Your Honor.
All right.
And I'm sorry, may I answer Judge Pan's?
Yes.
I don't mean to interrupt. I just
No,
want to
no.
make sure not to leave Judge Pan's question unanswered. The answer to that question, Your Honor, is that in Bell Helicopter, the only thing the court said was it's arguable basis unless it deals with sovereign immunity. Didn't say anything about conceding anything. And if it deals with sovereign immunity, it's a de novo standard of review. It's not arguable basis. So you'd have to read something more into Bell Helicopter to find that anything that Romania said in its appeal document somehow changes that review for purposes of Rule 60b-4. I'm sorry, Judge Pillard, did you have?
I was just going to say, under EU law, it seems like your key premise of your argument is that the arbitration agreement became void the moment that Romania acceded to the EU. But looking at the Court of Justice of the EU opinion, it said that Romania's standing offer to arbitrate was void, and that the arbitral award is invalid and unenforceable. But does that mean that the already completed arbitration agreement became void? I don't see that in the Court of Justice opinion.
Your Honor, that I think you've misunderstood our position, and perhaps I've not explained it well. So I'll take a run at it from a little different direction to see if I can offer some clarity. The point is this: the bit in this case, like we heard about other treaties earlier in the day, did not in fact say we agreed to arbitrate. What it said was there's sort of an outstanding offer to arbitrate, and the way you can accept as an investor, and it makes sense, right? Because the bit is between Romania and Sweden. So to create the arbitration agreement, the investor, the Miculas here, had to come forward and demand arbitration. That's the acceptance of arbitration. That's the formation of the arbitration agreement. That occurred in the summer of 2005. But earlier in 2005, Romania had signed the Act of Accession as part of the process of joining the EU and agreed to follow EU law, which meant, according to the CJEU in its decision 2 years ago, that meant that from that point forward, from when Romania signed the Act of Accession, it did not have the capacity to consent to arbitration. So there was never an agreement formed. And that's the issue for our present purposes. It's a formation question, which is for the courts. And when you say for the courts, that really means it's for the European courts, for the EU's highest court. And in this case, that's, of course, the CJEU.
Well, wasn't there a point about when the events at issue took place as well?
I'm sorry, Judge Rogers, I didn't quite hear you. I apologize.
Wasn't there also the distinction about when the events at issue took place?
Well, Your Honor, I don't know what it would be in distinction from, but I do know that the
In
CJEU.
other words, before Romania had joined the EU.
No, Your Honor, only some of the events occurred prior to Romania's joining the EU.
That's my point.
But well, I said only some. The CJEU held that there were some actions for which the Micula sought damages that occurred after that date. So there's both. And if Your Honors have no further questions, I'll, so to speak, reserve my time for rebuttal.
Fine. Thank you.
Thank you, Your Honors.
Good afternoon, Mr. Vasquez.
Good afternoon. May it please the court. I am Frank Vasquez. I'm here to argue on behalf of the petitioner appellees. I'm here with my colleagues, Jackie Chung and Hannah Rubashkin, and also my co-counsel, Anthony Ullman. In the district court's most recent decision, in the first sentence, he characterized this case as a seemingly never-ending saga. And I think that that kind of summarizes where we are. And I think you've already alluded to the fact that we are not in the same kind of posture or position as the other cases that you've been hearing today. And if you just review the 4 appeals, this is the 4th. The first one, we had the original judgment. And as Judge Pan observed, Romania did concede jurisdiction during that appeal in its papers, and this court observed that and affirmed the decision. In the second appeal, there was an argument by Romania that it had satisfied the judgment by making a partial payment. That motion was denied, and that this court then affirmed that. In the meantime, the district court also sanctioned Romania for failing to comply with discovery. The third appeal, there was the judgment on accrued sanctions was entered, and sanctions continue to accrue. Romania remains in contempt of Judge Maida at the district court level. Romania argued that it should have the stay of discovery. This court also affirmed that decision. Romania's motions were rejected. And now we're here on the 4th appeal, where Romania is now attacking the judgment under Rule 60. In our mind, and Judge Pan, you alluded to this, this is kind of like Spain saying, we don't want to pay. And that's our position, is that all of this litigation, which has been going on for 10 years, so that I've been involved with it, has been going on much longer than that, that Romania does not want to pay. One of the other things that happened, though, more recently, that also goes to Romania's concession of jurisdiction, is that Romania went back to ICSID. Romania went back to ICSID on a request for an interpretation of the award. And in doing so, Romania submitted to the jurisdiction of a reconstituted tribunal. We had that hearing last May. That decision was rendered in our favor in December, and we filed it as a supplemental authority on January 2nd. So that is further evidence that Romania has in fact conceded that the ICSID tribunal had jurisdiction over it to decide and issue the award that then needs to be enforced under the ICSID statute. And
So I'm interested in your Rule 60 arguments. On Rule 60B, you say that Romania's motion is time barred under Kemp versus United States because it's based on a judge's error of law. But doesn't that reading of Kemp swallow the rule? Is there any example of a void judgment that is not the product of an error of law?
No, not that I can point to on that. We did add that argument as a supplemental argument. Our principal argument is simply that the arguable basis standard applies and the judge correctly decided in the first case and also decided correctly following that. One other thing I think that needs to be clarified is we've heard from the European Commission today and also opposing counsel about the status of the CJEU and General District Court case. It's still going on. In fact, the parties will be presenting arguments next week in that case. It was that CJEU decision was really just a remand to the General District Court for further proceedings. And those are ongoing, and that will be argued next week. And many of these issues are on the table there, including whether this is state aid, including these timing issues about when the damages accrued.
How does that bear on the Rule 60, the appeal of the Rule 60 motion denial before us?
The only way it bears on it is I think there was a mischaracterization that was some kind of final pronouncement by the Court of Justice. So to the extent of that any decision would be based on that being a final order, it's not. It's still ongoing. We don't believe it's relevant ultimately, simply because, as Judge Maida found originally and subsequently, that the agreement to arbitrate originated before Romania ceded to the EU. The other issue that this case has been going on for so long.
Yeah, I have another just specific
Sure.
Rule 60 question, which is what's the standard of review? You say in your brief at one point that for the question whether the judgment was based on an earlier judgment that was vacated or reversed, we should review that for abuse of discretion. I wonder if you have authority for that. I would have thought that would be a question subject to de novo review.
Under 60B4 or 5?
60B5, district court denied the motion to vacate the judgment as based on an earlier judgment that was vacated.
Well, there has not been an earlier judgment that's been reversed or vacated.
But the standard of review, de novo or abuse of discretion? You say abuse of discretion. I'm just not sure.
We think it should be
authority for
an abuse of discretion, but the
Authority for that?
the result would be the same either way.
Okay. Any further questions?
So what I was saying about those proceedings ongoing is that what I was talking about earlier was this case has been going on for so long, it predates the Stillix case. So the original judgment did not have the benefit of this court's layout of how that decision should be decided. In fact, we think the court went beyond what it needed to do originally, and in terms of establishing jurisdiction. And then, as we've heard in earlier arguments today, that would be really established by the ICSID statute itself and the existence of ICSID 28 USC 1650A with those agreements that the court, in fact, did not need to go into the analysis it went into. It was, I think, convenient for the court to do that. It was consistent with the arguments that we've been making in the European Union about this, because we're trying to enforce this judgment in multiple jurisdictions. But in terms of how the court needs to decide this issue, we think the court went above and beyond what it originally needed to do.
You're talking about the district
The
court.
district court. And so I just want to make that clear, that if this case were to be brought again, it would be, there would be additional arguments based on precedent that was not available.
So just to put it on the table for today, the narrowest ground on which you could prevail in your view that you think would suffice would be?
Well, the narrowest ground would simply be the ground that the court articulated originally, which was that Romania was not a member of the EU. So all of these arguments about EU law applying and having something to do with, or to obviate, or to go against the arbitration agreement, or to negate it, are just not available because the EU law did not apply.
When you say the ground that we already ruled on, you mean this court?
Both this court in the first appeal and what the district court did in making that determination, in this court affirming the new information or CJU decisions did not change that analysis, as the court just most recently found.
Right.
We think the broader view would simply be that all of those questions are irrelevant, and the jurisdiction could have been found simply straight on the statutory authority of the exit statute.
Thank you. Do my colleagues have further questions? Thank you, Mr. Vasquez.
Thank you.
Mr. Fine, you have 2 minutes for rebuttal.
I take that particularly seriously when I see you start to gather your materials. It's a very subtle hint, Your Honor. I have 4 points to make, and of course, I'd like to answer any questions that the court has. The first is just to remind the panel, Romania has paid in full what it understands under the Micula's calculations, the award to be. So this isn't somebody trying to avoid paying an award, although honestly, Romania doesn't think it should have had to, but it has. The second point is that Mr. Vasquez refers to Romania going back to ICSID. That wasn't consent. That was because, number one, it was instructed to do so. And number two, Romania was trying to get clarification about what its obligations were under the award. That doesn't mean that it consents to it any more than it consented to be brought into the district court here. It had to answer. The third thing is that the Kemp case is of no value to the Miculas for what I think is the very reason, Judge Pillard, you mentioned, which is that what the Supreme Court said there was that if you're just saying the judgment was void because the judge was mistaken, that falls into B1, and that's a mistake, and that's got a 1-year thing. But here we're talking about something very specific. The judgment was void because under Bell Helicopter, the judgment was void. There was no subject matter jurisdiction. The specific rules over the general. The fourth thing is on the standard of review, these are all issues of law for which the court's standard of review is plenary. And let me finally just note that the situation in which Romania has found itself is candidly intolerable. Romania is bound by EU law. It has been ordered not to make these payments because the EU, the EC in particular, regards them as state aid. It's having orders from the district court in the United States telling it, you must do that. It's being told by the EC, don't do it. And by the way, claw back what you've already paid to the Miculas. That's not a situation in which Romania should find itself. And moreover, these are European parties, all of them. The interests there are European. They are European member states, and it should be determined according to EU law. In this dispute, courts of the United States do not have an interest. We ask that the court vacate the judgment below and remand with instructions for the district court to grant Romania's Rule 60B motion and vacate the judgment of September 11, 2019.
Thank you very much.
And thank you, Your Honors.
The case is submitted.
This honorable court is now adjourned until Monday at 9:30 a.m.